Good morning. Good morning. It is Thursday, June 15th. I can't believe we're midway through June. It's right before I leave for VidCon. And as I was getting ready for this morning's live stream, I just thought I would take a quick peek to see if there was a ruling in the Idaho case because we covered the Kohberger gag order hearings on Tuesday, and I wanted to circle back on that. I can't find the part 2 anywhere. So I've reached out to Court TV to try to find it. I don't know what's happening. We'll see. But we don't have a ruling yet, but we have a bunch of other stuff. And I was like, well, shoot. So we're going to be covering the bunch of other stuff, and then we're going to go into the Kouri Richins bail hearing. I will give you a very, very fast recap of that case. It is a new case. That should be clear from the fact that we're at a bail hearing. This is one of the first things that happens post-arrest. We haven't gotten to a preliminary hearing yet, but as we get into that case, I will tell you a bit about it. That is a longer bail hearing than it is as long as some trials. It is a long bail hearing. It's a few hours. So we're going to go through that whole bail hearing, and we will be doing that. So we will be going through Richins. We do not have the part 2 for Idaho, because it seems that when the court took a break, they didn't pick cameras back up again. I don't know why. Hopefully we'll get an answer to why. The court has not ruled yet on cameras in the courtroom, on the gag orders, on any of the motions. With that, there will be timestamps down below for those that are new. Occasionally I see an odd comment here and there that is, but it didn't start till this time. There's timestamps. There are timestamps. So, replay crew, love you. You can always find the timestamps down below. The live crew gets to be in the chat. So there's that. All right. With everything, we're going to go to Idaho, then we're going to go to Utah. That's what we're doing. Good to see you all. Let me know what you're drinking, where you're coming in from. I've got coffee, lots of it. I've got a tankard of coffee this morning. I've got water. I brought a straw for the water this morning because we need it. It's so much easier when streaming to straw. It is. You guys have been loving this cup from the Lawnard shop. I'm happy for it. So thank you for all of your support. It's fantastic. And then I will remind you now, and I will remind you again later, we have a members only live stream tomorrow. I'm going to tell you more about what's going on behind the scenes for VidCon. If you're interested in that, the members only live stream tomorrow afternoon is the place to be. I had to bump it from Wednesday because I had to get my hair done before going to VidCon, and I knew y'all would understand. We all said we refreshed the nails, we refreshed the hair. We're going to talk behind the scenes stuff, which creators have slid into my DMs to be like, hey girl, hey, can we meet up at VidCon? I love your channel. We're going to talk about the incredible amount of creator access only lounges and how those are kept separate from the rest of VidCon. We're going to talk all the things. So that will be on our members only live tomorrow. And a bunch of you are new members, thanks to B2, who is like just raining down memberships on the chat this morning. And thank you for that, B2. It's incredibly generous. It's always incredibly generous. And thank you for always gifting to this community. It's fantastic. Let's roll the proper intro today. 50-50 chance and get going. We should it's that kind of a day. We're just going to get started.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
I love seeing all of y'all coming in from all over the world. We're not judging what you're drinking because we don't know what time of day it is where you're at. I just assume if you're telling me that you're drinking wine or whatever, that it's because it's time for you to drink wine. I have no judgment here. So I love it. Drinking Pepsi Max this hot summer day in Sweden. What temperature is hot in Sweden? It has been actually cooler here in Middle Tennessee, and all of my family in California is like, so apparently California is now Seattle, and we haven't seen the sun in like a month and a half. And I'm like, June gloom has gone extensive in Southern California, so it is cold there. So I love seeing how many of you hydrated. Question: no sticker on the mug. This is printed into the mug. It's sublimated, but yes, the design is on both sides. But this is not This is sublimated into the mug. So it is in there. It is printed. I'm not going to go through the process of sublimation because I will expose exactly how little I know about the sublimation. I do know the difference between sublimation and UV printing, and that's more than I ever wanted to know in the first place. We have people who help. I love the shop. We've all learned, Team Baker has all learned more about the shop than we thought we were going to. Hello, Brazil. I love seeing a lot of you are drinking energy drinks. But I love our law nerds. You guys are the best. It's so good to see you. It was 100 degrees here in Arizona yesterday. It's probably why it's Amy Van Dyken's time to leave for Colorado. She's like, yep, it's getting time to leave for Colorado. So she is heading out of Arizona into the mountains. Sun's out here north of Seattle. See, the Californians should go summer in Seattle. Seattle in the summer though, low key, gorgeous. I don't think people realize, people sleep on Seattle. Gorgeous. Like Washington is so gorgeous in the summer. I enjoyed Washington in the winter, but I'm kind of a vampire anyway. So I'm okay with it being like dark and stormy. I'm fine with it. But the summer in Washington is so glorious. It's so glorious. I loved it so much. And before we moved to Seattle, I lived in Seattle during the beginning of law school. I lived in Seattle. We had always gone up and visited during lovely weather. And so my husband was like, it's not always going to be like this. I'm like, no, I know, it's fine. Like, miss me with Western Massachusetts weather. Like, it snows and then it's muddy and then my hair's frozen. And like, that was too cold for me. Like, I can't do all that. But the Pacific Northwest, I'm like, this I can do. This I can do. This is lovely. I see the chat saying, Emily, don't spill the PNW secrets. Sorry. Okay, you all hate it. Look, not everybody is built for the Pacific Northwest. There is definitely a solid period of time where you get up in the morning, it's dark, you get home from your day and it's dark. Not everybody is cut out for that, but it is great. So I see the Washingtonians are like, stop it. Okay, sorry. You'll hate it. Never go. I enjoyed it. It's a great place to visit. Go visit. How about that? And there's the IKEA in Washington was glorious. You know what they don't have in Nashville? We're getting an In-N-Out. No IKEA at all. I'm like, how is there not an IKEA? How is there not an IKEA? Have to go all the way down to Atlanta. I love going to Atlanta though. All right. With all of that, shall we get started? What the fuck is going on, Utah? What the fuck is going on, Idaho? What are we doing? I thought that we had like a week break. I have already planned the podcast that I'm recording for next week. So there's a new podcast for you while I'm at VidCon. I have already planned all the things. And then Idaho is just dropping new motions that are allegedly from the 13th, but you know how they do. They don't pop up on the website for days. And there are 4 things. We're going to go to the wildest one first. No, I know there's an IKEA in Memphis, but from where I live, it's faster for me in my car with the charging to get to Atlanta than it is to get to Memphis. I know there's one in Memphis, but Memphis is not Nashville. Next time I'll come to the IKEA in Memphis and hit up all the Memphis law nerds. How about that? I'll do that. All right, so let's get to all of the wildness that's happening in Idaho. I was really surprised by this motion. I did not see this coming. I often don't. I was like, what are you doing? So let's just go to the one that's the wildest first, and then we'll work our way backwards, shall we? Like, let's just not bury the lead, right? The timestamp jockeys that pop in and are like, you didn't. It's not the law nerds. It's the people who wander by the channel and then leave because I talk too much. It's them. We're going with the big news first. Let me share my screen before I swoop because we're professionals here. Why is my screen not shared? Because I only share my screen every single stream. Why would it be ready? Why would it be ready? Oh, no, I don't want to do that. There we go. Hi, friends. All right. This is the district court for the 2nd Judicial District of the state of Idaho in and for the county of Latah. Look, a lot of you asked why during the hearing on Tuesday you saw the logo from the media company in the presentation saying that it was property of the Kutani Public Defender's Office. I'm sorry if I pronounced your county wrong in Idaho. I apologize. But that is where Ann Taylor is public defender. So that is Ann Taylor's. That is where she is public defender. Ann Taylor is one of the few public defenders in the state that is death penalty qualified. There aren't that many. And so Ann Taylor is coming in from another county to hear this case is in Latah. And for attorneys that are in the same state, practicing in one county versus another is not tremendously different. It's not like you need to be a member of a different bar. She's just the public defender in another county and is covering this case in Latah. But yes, Nikki Crayons in the chat pointed out she's the only one in Northern Idaho. Yes, she's the only death penalty qualified defense attorney in Northern Idaho, but there are only a very few in the state. So that is why we are coming from another county. So thank you all for the pronunciation guides. I'm sure in one of my 7 pronunciations, I said Kootenai. No, I didn't. Not at all. So there we go. Thanks everybody. Let's go with the motion to stay proceedings. For all of you that are like, Emily, stay means pause. The fuck? Yeah. Bryan Kohberger did not waive his right to speedy trial, and his attorneys are filing a motion to stay the proceedings. Y'all surprised? I'm surprised. I'm surprised. Procedural background. Mr. Kohberger was indicted by grand jury on May 16th, 2023. He filed a motion to make available the record of all proceedings of the grand jury pursuant to ICR, Idaho Criminal Rules 6.2, and a motion requesting release of grand jury materials under qualified protective order on May 19th. The state then filed their state's response to defendant's motion regarding grand jury record and transcript. It doesn't help if I try to do it fast and then trip over my own words. Boo. And a proposed order on May 30th, 2023. The parties are not able to reach agreement regarding the release of grand jury materials. This means the court is going to have to deal with this discovery request and is going to have to go through the grand jury materials and decide what is disclosable, what is not disclosable, what the defense gets, what they don't get. In further opposition of Mr. Kohberger's motion for the preparation of grand jury records on June 6th, the state filed their state's supplemental response to defendant's motion regarding grand jury record and transcript. See, that was better. A hearing is scheduled for June 26th. Mark the calendars. I want to see that hearing. I want to know what's in those grand jury records, and maybe we'll get to know a little bit. If there's cameras in that hearing, fingers crossed. To argue this contested matter, this I want to see. Mr. Kohberger stood silent at his initial arraignment to preserve his right to contest the indictment. If you contest the indictment, this case is not going to go to trial in November, in October. If you contest the indictment, this trial is not going to trial anytime soon at all. He also asserted his right to a speedy trial pursuant to the United States and Idaho Constitutions. Great. Jury trial is scheduled to begin October 2nd. We should start taking bets on whether this jury trial starts on October 2nd. I'm going no at this moment. I'm going outside chance that it actually starts October 2nd. Like way outside. Argument. By the time the court hears argument on the preparation of the grand jury proceedings, almost 6 weeks will have passed from the time of the indictment. Preparation of the grand jury record will then take additional time. So from the time they agree on what gets turned over, it will then take time to actually turn it over. Mr. Kohberger has the right and intends to contest the indictment. That is new information. We saw Kohberger's defense attorney tell the court that the reason that he stood silent, because the only way they could talk to the media about it, and I think that's what they were doing, speculation on my part, I think what they were doing was telling the media why they stood silent, because they can't answer the media directly because of the non-dissemination order. So they said in court, hey, we stood silent because it preserves the right to contest the indictment. And now we see them saying in a motion, we are going to contest the indictment. Here's the thing. If the indictment gets yeeted, which is deeply unlikely, unless there is substantial fuckery, which is also deeply unlikely, but there's always an outside possibility. It's law. It always depends on the facts. And the facts in this case, we just don't fucking know most of because there's a non-dissemination order. And a lot of this information just isn't public yet to preserve, an impartial jury and the defendant's right of presumption of innocence and the rest of it. We don't know everything, but it's unlikely that the indictment gets yeeted. But if the indictment gets yeeted, they'll just do a preliminary hearing. Like that's what happens. What happens if they contest the indictment and it gets somehow thrown out? Well, then you just go to the preliminary hearing. So let's talk about this more. I see a lot of you asking about contesting an indictment. We're going to keep reading together and then we'll talk about that. Preparation of the grand jury record will take additional time. Kohberger has the right and intends to contest the indictment. Idaho Code 2-2131 allows the defense to seek a stay of proceedings. Within 7 days after the moving party discovers or by the exercise of diligence could have discovered the grounds therefor, and in the event before the trial jury is sworn to try the case, a party may move to stay proceedings and in a criminal case to quash the indictment. So one of the grounds in a criminal case to stay the proceedings, to pause the proceedings, put a pin in it for later, is to challenge the indictment. Let me finish reading and then I'll explain. Or for other appropriate relief on the ground of substantial failure to comply with this chapter in selecting the grand jury. I don't know if that ground is there on the ground of substantial failure to comply with this chapter in selecting the grand or trial jury. I don't know if there's failure in selecting the grand jury. We'll see. We'll see. I wanted to grab a comment I saw from Sarah. Sarah, his attorneys, I appreciate this question. His attorneys are doing everything they can because he is facing the death penalty. So we're just seeing it. A lot of death penalty cases we do not see from the outset like this. The motion for stay kind of surprised me. A lot of defendants will just waive time, but his attorneys are doing their job. And their job is to challenge everything. Because at the end of the day, what Bryan Kohberger is facing right now is the death penalty. And so it is his attorney's job and obligation to literally do the most all the time. We don't always see that. Normally, when cases pick up interest is right as they're going to trial. So for a lot of us, we don't see the ins and outs of the pre-trial litigation before trial. For those of us that practice in criminal law, we see it. And in bigger cases, you see more of the ins and outs of pretrial practice because there is much, much more on the line. And the stakes are higher. So them raising every possible motion they can indicates to me, A, this public defender's office has the time and capacity to do this. This is probably one of the only death penalty cases that these attorneys are handling at the time versus other jurisdictions where sometimes attorneys will have multiple death penalty cases at once. There aren't that many death penalty cases going on in the state in the entire state at the moment. So it's really helpful I think, to see the criminal proceedings from the beginning, to know that this is part of the defense. And I would always ask the chat to ask yourself, if this was someone I knew, wouldn't I want their defense attorney to do everything? The flip side of that is when you are thinking of the victims' families, and when you see how the victims' families are feeling, you're like, but if you're the victims' families, don't you want this to move forward quickly so they can move on? Yes. And those two things push and pull at each other all the time. But at the end of the day, that push-pull, the defendant's rights are generally what is going to come out on top because of the constitutional rights to due process. And that's what we're going to see. Here's my perspective on it. For me, I like seeing the defense attorneys leaving no stone unturned, because if there is a conviction, there's way less grounds for appeal. So by the time you get to a conviction, if there's a conviction, by the time you get there, it's much more of a closed case. If you see a case where not a lot was done, it leaves a lot more stones to uncover, or I don't know, chips or whiffs or something. There's probably a golf analogy here that I'm missing, but it leaves a lot more stones to uncover to appeal. So I would rather have them do everything before. Sarah, it feels like defendants get more rights than victims. That's not a feeling, that's a fact. No, that's true. And you're feeling that way because that's true. And it's really frustrating. I completely get it. Victims have more rights now than they did. The victims' bills of rights passed by different states are making it better. It's making communication with victims better. But victims are not represented by anyone in the criminal process. They are not represented by the police. They are not represented by the district attorneys. They are a massive part of it, but they're not represented. It is a really awful function of our system. A criminal defendant wouldn't be in the criminal system if there wasn't, well, that's not necessarily true. We can't make broad sweeping strokes because there are lots of victimless crimes. But oftentimes, when someone is a victim of a crime and they make a police report, it's discovered what happens, somebody is arrested. After that, the process goes running off into the criminal courts, and the victims are left to work really with the victim witness coordinators to stay in touch with what's happening. But up until you get to really a sentencing, they don't have a ton of a voice in what's going on unless they are percipient witnesses. So it's different with murder victims than with like an assault victim who's like, this is exactly what happened and they're coming in to testify at trial. It's a bit different, but the system is not easy for victims to navigate. And it's why you see a lot of victims not wanting to navigate it. It's really tough because the rights with the defendant are constitutionally granted rights. And so you end up in this situation where you're like, right, but the victims were just like living life. And then this thing happened. Generally, by the time you arrest the person, that that's the person we suspect did the thing. And then their rights are protected. And the victims are like, and I'm what? And that is a push-pull. So we're starting to see more attorneys speak up in court for victims, which we're also seeing in this case. That's where Shannon Gray comes in. He is the attorney representing the victim's Gonsalves family. So he can come into court and say they have a right to have a voice too, where normally, unless they are a witness in the case because they are a surviving victim and they saw things and can testify, then there's really not much for them to do other than be kept in the loop. And that's really hard. And in murder cases, that is really hard because the families feel like there's nothing they can do to fight for their loved one because there's nothing they can do. The system has taken off, the process has taken off, and it continues to roll. The process has its own thing. and the rights of the defendant come up first. And that's a very difficult thing to square in our system, and something I didn't think about as closely when I became a district attorney as when I started working within the system. And then you're like, oh, like I've heard people be frustrated. I've known victims of crime before I became a district attorney. I've talked to people about their experience. Part of the reason I became a district attorney was because of those conversations and those experiences. And I'm like, I can do it better. But when you are working in a huge system, sometimes better is really hard to fight for. And that is a push-pull. And at the end of the day, the criminal justice system is not really set up to make victims whole. It is set up to punish defendants. And that's difficult because oftentimes the victims feel lost, which is why there are growing and more victims' rights organizations, why prosecution's offices have victims' witness assistants. I don't know of any prosecution offices that don't have them. Victim witness assistance is an absolutely needed and incredible thing. And we saw that work really well in the Brooks case. You saw how thankful the victims were for their victim witness assistants or victim witness coordinators who kept them in the loop and made them feel supported. But that is going to vary vastly depending on the office and depending on the individual who takes on the job of holding space and sitting with people during the worst time of their life, going through the worst thing they have ever been through. It takes a very, very strong and special person to take that job and to do that job really well. And for those that do, it's absolutely incredible. But not everyone does. And some offices put people in victim support and are like, hey, I know that you worked in this area. We need you in victim support. Oh boy. No, don't just do that to people. That's not healthy for them either. But it is an area that you can go into. And it is super needed. Super needed. So I didn't mean to rant about victims' rights. So it's hard. Enchanted Wings, thank you for sharing your experience in the chat of a survivor of a few crimes. I felt lost. I needed therapy to overcome the trauma. Yeah. And that's often not the first thing that's offered. There's a whole lot of like scheduling and dates, and it gets very systematic, right? Because for the people working in the criminal justice system, it gets very routine. I kind of likened it to this. So we're going to do a quick sidebar, and then we're going to finish this motion. Sorry for the sidebar. So we're going to get into a little bit of TMI, but I promise it won't be too much TMI, but I had very difficult pregnancies. So when my first was born, it was an emergency C-section. He was in the NICU for a month. There was a lot going on. And if anyone's been through that experience, you know that if you are the mother laying there after everything has happened, everyone takes baby. Everyone is out of the room, except for the people that are finished putting your body back together because they've taken your body apart. So my doctor, who I adored, and the other doctors who were kind of putting me back together, were chatting about the Lakers. And I am on the other side of the blue sheet with like tears. You can't wipe the tears that are rolling down your face because your arms are strapped down. So you're just like laying there, and they're just like chatting about, their day, about the Laker game, about whatever. And I'm just laying there. I'm like, what they've got is a blue sheet and all of my bits and pieces, but it's their work day. This is what they do. This is their work day. And it changed the way I approached court, because there were days in court that I was chatting with the defense attorney, like at the bar, like, oh my God, what did you guys do last night? You went out to dinner. Oh, I love this. Have you tried this new restaurant? And we're chatting. But there are defendant's family and victim's family in the court, and it's just our work day, and we're just chatting with our coworkers. But this is for them scary, disorienting, hugely consequential. And for me, I have 100 and whatever cases, and these are defense attorneys I like, so we're just having a chitty chat before case starts. The same way that my doctor and the other surgeons were, they were having a chitty chat with their coworkers, the way you would at maybe the water cooler. But when there is somebody else present to that, this is not the water cooler for them. This is terrifying for them. And it changed the way that I engaged with attorneys in court when there was a gallery present. Because I'm like, we can have a chitty chat in the hallway. We can have a chitty chat in the office. You can come by my office and chat with me. But when I am in the courtroom, you don't know who's sitting in the courtroom, especially when you're going through lots of cases. And so I didn't want them to feel like their case wasn't as important to me as it is to them. And it's, of course, never going to be as important to me as it is to them. But they shouldn't feel like I'm just like, oh, yeah, so can we just... Yeah, I know. I'm on level 300 and bejeweled. Right. No, how about you? I don't want anyone to feel that way. And I didn't really notice how much our just rote colleague banter in court could be disorienting for those sitting in court terrified. I'm not terrified. This is where I work. These are my colleagues. This is what I do every day. But for someone who's never walked into a courtroom before, terrifying. And I was like, I can do this better. And I can be less, I want to be collegial with the attorneys, but not to the extent that it puts off any of those in the gallery, because this is hard for them and this is stressful for them. And you don't know where in their day you are finding it. And so it changed the way I interacted in court. And I know other attorneys that have had these moments too, but it's not something that they necessarily teach you. It's something that they always tell you, like, you never know who's listening in court. But a lot of attorneys in the criminal system have never been on the other side of that. I mean, a lot of attorneys, period, have never been on the other side of that. So you don't quite know what that's like for them. And I don't think it would be easy for a victim's family to be like, hey, so you're joking around with the defense attorney and that feels real fucking gross to us. Because that's real hard for them to say you're the DA on their case. So that is one of the things that with being in court, being mindful of who is around, and also having the victim's witness assistants in court also signals to the DAs. You can visually see who's in court because then you know, even if it's not on your case, because there's multiple cases through a courtroom. And also making sure that they know that this is not, that the attorney's chatting is not disrespectful. So that Pacific case. Well, thank you. That's what it is. It's important to remember. And I think in any workplace where the public is in your workplace, to remember that sometimes you're on stage and sometimes you're not on stage, and remembering what on like front of house and back of house looks like in different professions. And it's not something that's talked about in law a lot. So with all of that, thank you all for the love for the sidebars. Kohberger. Kohberger. Let's finish this motion. Let's see. Substantial failure to comply with this chapter and selecting grand or trial jury. So now we know the grounds for the motion, but I don't know if they will find the grounds here. So the grounds for the motion are that there was a substantial failure. That is going to be a hard standard to meet. A substantial failure to comply with the code, stick to the code, to comply with the code in selecting the jury. What did they do? I don't know. What are they accusing? What are they accusing the prosecution of doing in not complying with the chapter and selecting the trial jury or the grand jury? Apologies. Rihanna, thank you for the work that you do. See, and I imagine doulas are much more tuned into that than surgeons. And the thing with C-sections is you're awake. Like, I don't care what my spinal surgeon is saying during spine surgery. I don't know what they're saying. But when I'm awake, I very much care. I very much care. Mr. Kohberger seeks to stay the proceedings as appropriate relief while the matter of the grand jury record is argued and prepared. I don't know if they can do that. I don't know if you can do that because that's not the grounds, right? All about craft. I see your comment. Thank you so much. I'm sorry that happened. I'm just going to pull it up. You just validated everything I went through in court during my daughter's sexual abuse case. The DPP was laughing with the defense barrister. And it feels gross, right? And it's hard because, again, for them, this is their workplace and they don't always think about it. But your feelings are absolutely valid. Absolutely valid. And if there is a victim witness assistant, if that is still ongoing, talk to them about it. Say, this made me feel weird. I can't guarantee that all attorneys will be mindful of that. Can't guarantee it at all. But there were a lot of defense attorneys I worked with that I very much liked. So when I saw them, I was like, how are your kids? How was your weekend? We were friendly colleagues. It's different once the public comes into the courtroom, right? Okay. Seeks to stay the proceedings as appropriate relief. But the code says, legal reading of the code says there needs to be a substantial failure to comply with this chapter. I don't know if they can argue that there's a substantial failure to comply when they don't have the documents yet. And that's where the defense is kind of in a catch-22 here, because they can't know if they can argue this without the documents. But it's going to take them the rest of the month to get the documents, right? It's another 10 days before they hear that argument. I just don't know if I don't know if they can do this. I don't know if this process is going to work for them the way they think it is, because it's not the relief that they are seeking is not the relief that this part of the code that they have cited specifies. And this is where picky legal reading comes in, because it very clearly says on the ground of substantial failure. Grounds. Kohberger seeks to stay proceedings. He is exercising due diligence to discover the grounds. At least they said it out loud. He is trying to discover the grounds upon which to file a motion to dismiss related to how the grand jury was selected. I don't know. What is your footnote? Mr. Kohberger will comply with filing a sworn statement of facts in accordance as soon as he has the grand jury record. So they are going to try to dismiss the grand jury once they have it. But they are saying he is being delayed because he doesn't have the grand jury proceedings yet. I don't know if a stay at this time is what he is going to get, or if the court will grant a stay after the hearing and say a stay will be granted, and a stay means the time is frozen, kind of like in Breath of the Wild where you can freeze time. So time is frozen until they're able to make their motion. And that might be kind of the proper remedy, saying, hey, we believe there's been a failure. We want to make our motion. And you stay time from the time the defense gets the documents to the time they make the motion. That might be the remedy we see here. But I don't think you can stay it at this point. We'll see what the court does. Kohberger's request to stay proceedings until the grand jury record is prepared and he has adequate time to contest the indictment. So he wants the case stayed now until he can make a motion to yeet the grand jury indictment. The remedies allowed in Idaho are the exclusive means by which a person accused of a crime may challenge the grand jury on the ground that the grand jury was not selected in conformity with this chapter. So the only way they can challenge a grand jury is that the selection process of the grand jury was wrong, and that makes sense. So for all of you that asked, how can you even challenge a grand jury? That is how. Under Idaho Code 2-213 sub 3. And that is lawful law. I see you, chat. That is lawful law. So they're arguing that a stay of proceedings is appropriate here. We'll see what the court does. They're allowed to seek a stay of proceedings. I just don't know if I read this wrong. Let me see. Let's read it one more time. A party may stay the proceeding and in a criminal case quash the indictment or for other appropriate relief on the ground of substantial failure. I wonder if the way the courts interpret this, though, is to let them stay it while they're making that motion. We'll see. I would have to go to the notes on this, and I will be interested to see. Oh, thank you. The theater nerd. I think that is what that is. I messed up this morning when buying my Pride merch. I originally sent the merch to my parents' address. Team Baker got it switched. Many thanks. You're welcome. Team Baker is here to help, and they are great. I love our team. So let's go to the next motion in Idaho. Bryan Kohberger is seeking to stay the proceedings. Let's talk about what that means real quick. What happens if the proceedings are stayed? There is a 6-month clock in Idaho from the time you are indicted or your preliminary hearing is done, when you're held over, when probable cause is found to hold you over, to when you go to trial. They don't want to waive their speedy trial right. They want their 6-month clock. However, they're saying that within that 6-month clock, they should be given a pause on the clock for the period of time it takes to challenge the grand jury. So if it takes 3 months for them to challenge the grand jury, that 3 months isn't subtracted from the speedy trial time, because they're going to need that time to prepare for trial. But they also don't want to give the state a waiver at this point, because once you waive your right to speedy trial, shit can be like 3 years on plus. The only way to keep things moving is to not waive that. Now, if the defense shows up 5 months into their clock and says we're not going to be ready, they can waive it. They can waive their speedy trial right later. They don't want to do that now. They want to put a pause on it for now, take care of this motion, and then keep going. And so that's what they are trying to do, which allows them to keep their speedy trial right and push the prosecution to trial within 6 months, and also have the time they need to prepare this motion. Do they get to do that? Yes. Do I think they probably need all the time that they can get? Yes. But do I think the defense is really mindful of not allowing this case to just run off into into years of time? Yes. I think they don't want that too. They want to have their cake and eat it too. They might get to for this. They might get to for a little bit of this. But it also makes sense why they want to do it this way. And if the law gives them the right to do it, then they have the right to do it, and there's not much that can be done. That is the law. They're allowed to do it. It's just like standing silent. People are like, why would he do that? Well, he's allowed to. Look, man, if you can make the rules work to your favor, do that. Do that. So, notice of hearing. This just popped up as well. I swear I look at this website every single freaking day. There's always new stuff. Notice of hearing, June 27th. Notice is hereby given that Bryan C. Kohberger, Bryan through his attorney, will call for a hearing on defendant's motion for an exception or in the alternative to extend time for compliance. So there is a hearing on the 26th and the 27th for compliance with IC 19-519 in the above titled matter on 6/27 at 1:30. So we have back-to-back motions. Okay. I don't think we've covered that motion yet. Let's go cover that motion real quick, because this is regarding the alibi stuff, to the best of my memory. So let's go pull that up Because now we have hearings on both. First, I'm pulling up the law. This is the alibi stuff. So let's swoop real quick. Bryan Kohberger's alibi. The defense has been asking for more time to provide notice of alibi to the prosecution. There are statutory rules about when this has to be presented if you're going to present it at trial. Kohberger has been asking for more time. So he's been asking for more time, and they don't say alibi in it. They always say their IC 19-519, but that's what 19-519 is. I pulled up 19-519 so we could just look at it together because I thought sometimes explaining the law is helpful. 19-519, notice of defensive alibi. At any time after arraignment, before a magistrate, upon a complaint, and upon written demand of the prosecuting attorney, which they did, the prosecuting attorney said, we demand a written notice of his intention to offer a defense of alibi. Such notice by the defendant shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of witnesses upon whom he intends to rely to establish such alibi. Within 10 days after receipt of the defendant's notice of alibi, but in no event less than 10 days before trial, unless the court otherwise directs, the prosecuting attorney shall serve upon the defendant or his attorney a written notice stating the names and addresses of the witness whom the prosecution intends to rely on to establish the defendant's presence at the scene of the alleged offense. So this is very much spelling out when the defendant has to tell the prosecution that there is an alibi, when the prosecution has to tell the defendant how they're going to prove that there isn't an alibi or rebut the alibi, and it is laying it out. There are no surprises in criminal court, or there shouldn't be. Here it is. This. And then they go through the other rules of what happens if you don't. Upon the failure of either party to comply with such requirements, the court may exclude the testimony of undisclosed witnesses, and that is what they will often do, offered by such party as to the defendant's absence from or presence at the scene of the alleged offense. You can't just spring it on people. Sometimes there's good cause. For good cause shown, the court may grant an exception to any of the requirements. Sometimes there's good cause. Like, we could not find this person and we didn't know their name. It's rare. So the defense wants more time to turn over their alibi. The state has feelings about this. So we're still talking about the alibi, notice of alibi. The state has feelings about Bryan Kohberger's notice of alibi. Comes now the state of Idaho. On the defendant's motion for an exception or in the alternative to extend time for compliance with IC 19-519. They're trying to enlarge the time here. The state acknowledges that the discovery in this case is substantial and ongoing. The state also recognized that this case is currently set for jury trial, projected to last 4 to 6 weeks and beginning in less than 4 months. Balancing the above, the state has no objection. Wait, what? Oh, Emily, don't say the state has feelings and the state comes in and is like, we don't care. Keep reading, bitch. The state's like, meh. The state has feelings. Here's the state's feelings about the defendant wanting more time. Okay. Sure. The state has no objection to a reasonable extension of time for the defense to comply with its obligations. They'll probably talk about this on the 26th instead of having a hearing on the 27th then, with the understanding and the expectation exception that the state will likewise have a reasonable period of time to respond to any proffered notice of alibi. Well, the code says you have 10 days. And with the additional understanding that any defense in compliance will occur by July 24th. The state's like, all right, well, as long as you get it to us by July, we're fine. That's fine. I meant the state's feelings were meh. We'll give you another month. All right, so they've got another month. Great. Yay for them. which means they probably won't do that hearing on the 26th. And then with regard to the grand jury, that hearing is going to happen on the 26th. And the defense wants a stay during that time. So those are all the Idaho motions. We are almost 50 minutes in, and we have quite an extensive hearing before us. So let us swoop-a-doop and talk about Kouri Richins. Are you ready? Are you ready? All right, let's make a swoop, and then we'll get, Emily, make that screen full screen. We got to switch things over. Let's swoop and talk about Kouri Richins. If you've heard about this case, it's because Kouri Richins is accused of killing her husband and writing a children's book about grief and then doing like local TV about that. She was arrested, and I still have questions about the circumstances because I have not seen a lot of information about how a year after the murder she is arrested. This is before the preliminary hearing. This is before anything else happens, and this is a bond hearing. So she is accused of poisoning her husband. She then wrote a children's book about grief. The grief book is a fact. The rest of it, we don't know. So then she went on and was promoting the book. She was arrested in May. They are trying to get her out of custody. Bail or bond hearings are generally Your Honor, please set bail. Bail does not have to be set in every single case. We will see the court grapple with that. There will be witnesses called. This is a long hearing, and we will learn a lot more about this case based on that. The questions I have outstanding on this case. What led them to arrest her a year later? That is my biggest question outstanding. Biggest one. And if we see anything in the hearing, now we'll know what's happening. So with that, we are going to cover this hearing. I am going, let me make sure the audio is good. We're going to cover this hearing from KUTV2 News Salt Lake City, because this is a Utah case, and they provided such clean feeds during the Paltrow case, and we appreciate them for that. So this is going to be interesting because there's live witnesses, and we're going to learn a lot more about what's alleged here. This is a criminal case. This is a first-degree murder case. There are other charges, including intent to distribute, which is odd to me. It's alleged that she overdosed or poisoned her husband with fentanyl. So we will see what happens. And I want to know if the book and the TV and those interviews are what led to them looking more into her. Maybe we'll find out during this hearing. Some of you have probably already watched it. No spoilers. No spoilers. I'm going to speed this up to 1.0. Closed caption. Let's do that. I'm going to speed this up to 1.25. Don't we love it when they let us have our closed captions? We sure do. Let's go. You ready? Let's go. I can't hear anything. No, I hear nothing. Well, that's not helpful. Why do I hear nothing? Let's slow this down. The court might just not be on record yet to where we can hear, because they are talking before court, and you generally can't hear the conversations of the defendant with their counsel before court starts. This also looks like it might be a little sped up, but if that keeps being crackly, I am going to not be okay. There we go. People are... Well, that's delightful. They are trying to get their audio up. Did I just compliment this news station? I did. This is probably from the feed that is a pooled feed going out. So, but we're not going to be able to hear what the attorneys are saying either way. So I'm going to speed this back up so we get to the beginning of this hearing as people are filing in to court. I do not hear anything yet. We do not have a court. The judge is not on the record. Emily, should you have prepared this before? Maybe. This is going to be a very packed courtroom with we've got a witness on the stand. And we're not even, I might switch feeds. Emily, should you have tested your feed? Yes. Hopefully this is not after, there we go. All right.
Given the amount of time I've been here,
If this starts in the middle, I'm going to be real frustrated, but it looks like this hearing might be starting in the middle.
it's somewhat customary for people to prepare.
Nope. All right. This is why I pulled two feeds. This starts in the middle of the hearing. I was really excited. I thought they had cut out the various breaks, but no, that starts in the middle, and that is terrible. All right, I'll pull the other one up. This is why I pulled two. Sorry, y'all, for the switcheroo.
Good morning, Ms. Richins.
This one at least starts in the middle, and I can hear it. So let's see if we can. No closed captioning, though. Oh, there we go. All right. That was delightful. Let's try again.
Can I have counsel for the state make their appearance, please?
Yay.
Yeah, sure.
This is the beginning of the hearing. I'm going to put this at 1.25 just because it is a long hearing. This was on Monday and we're not in real time, but the sound is much better. So we're going to just do this. Let me make sure y'all can hear. It got real choppy on that sound. And I can't, you know how I feel about that. Well, I was so optimistic. So optimistic.
Patricia Cassell for the state.
Your Honor, Brad Bloodworth for the state.
Joseph Hill on behalf of the state.
Welcome. Thank
Four?
you. On behalf of Ms. Richins, please.
4 prosecutors. 4.
Thank you, Your Honor. Good morning. Sky Lazaro on behalf of Ms. Richins.
Aaron Hinton on behalf of Ms. Richins.
Thank you.
2 defense attorneys. I'm going to gain this volume up one more time. And see if that's better. All right.
All right. We're here today for a detention hearing to determine whether Ms. Richins will continue to be held without bail during the pretrial period. I've read a lot of stuff. I've reviewed the defendant's motion to consider defendant's
I've read a lot of stuff. So there's been thorough motion practice before this.
constitutional right to bail, the state's bench brief, defendant's motion to set conditions for release, the state's response, and I read your reply filed last evening, Ms. Lazaro.
Thank you. I apologize for that.
It's fine. This is a dynamic situation.
As
I'd like
bail
to hear
hearings
from
are.
the state first. Who's leading the
I
presentation?
am, Your Honor.
Ms. Cassell, how would you like to proceed?
This is a very full courtroom. And from news media, I understand that that courtroom is a lot of family members from the community.
Your Honor, we have 3 witnesses that we would like to call.
Okay.
We are prepared to call them now.
Who's the first witness?
The first witness is Detective O'Driscoll.
Do we have an exclusionary rule issue? I'm not sure it applies today, but I thought I'd ask.
I'm not sure it does either, given sort of the loose nature as far as the rules go on this
It
hearing.
kinda doesn't
Given
apply.
the nature of the proceedings, and I'm sure what's to come, extensive testimony in this case and a number of different issues, I would ask that it be imposed.
I mean,
Yes.
1101C4 would say the rules of evidence do not apply today.
That is correct.
Exclusionary rules, a rule of evidence.
Those don't apply.
It's a reasonable request, but it's denied.
Thank you.
I like this judge a lot. I like this defense attorney. I have not watched this. The exclusionary rule means we're never going to get through this if I keep pausing. It's going to be fine. The exclusionary rule means that witnesses can't sit in where other witnesses are testifying. Those rules of evidence do not apply at a bail hearing. And he said, do you want to make the motion? And she's like, well, I'm not sure it applies here, but I'm going to ask, which is, for a defense attorney, very straightforward. Doing their job, like, Your Honor, I acknowledge that the rules don't really apply, but I'll ask. And I appreciate that.
Is it Detective O'Driscoll?
Yes.
Okay, if you'd step in front of Brittany, we'll get you sworn in.
First witness is going to be a detective. The defense is asking for the defendant to be
You
allowed
solemnly
out
swear
on
the testimony
bail.
you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury.
Oof, camera. And is going to testify about, well, the reason that this defendant might be a danger to the community, the sophistication of the crime, and the rest of it, why this defendant shouldn't be allowed out on bail.
Good morning, Detective O'Driscoll. Can you please introduce yourself to the court and explain your relation to this case?
My name is Detective O'Driscoll. I've been with the Summit County Sheriff's Office for 7 years. I'm assigned to the Investigations Division. I was assigned to be the lead detective in this case in April of this year. This case is an active case and the investigation's ongoing.
Detective, what was the sheriff's office first involved?
They started investigating, did you catch that? In April of this year. The death happened in March of last year. So something changed in April of this year. And then she was arrested in May. So whatever happened that they discovered went quick from April, from an investigation in April, or this detective coming in April, to an arrest in May, to a bail hearing.
Involvement in this case?
On March 4th, 2022,
That's when he was assigned.
3:22 hours,
Yep.
Summit County Dispatch received a 911 call regarding an unresponsive
But he
male in the
seems to be
Francis area.
lead.
Have you listened to that 911 call?
Yes,
Who placed that call?
the defendant, Kouri Richins.
In addition to saying that someone was unresponsive, did Ms. Richins, the defendant, identify who was unresponsive and anything else about that person's condition?
Yes, she stated that it was her husband, Eric Richins, that was unresponsive, that he was cold to the touch and not breathing.
Did EMS and police respond to that address?
Yes,
Is that the family home?
yes,
Was a portion of the police and EMS response captured on police body camera video?
yes it was.
Have you reviewed that video?
Yes, I have.
On that video, what time does EMS pronounce Eric Richins dead?
03:58 hours on March 4th.
What, if anything else, does EMS say about how long he had been dead?
One of the EMS personnel made the comment that he had been dead a while.
Did the state medical examiner's office conduct an autopsy of Mr. Richins?
Yes, they did.
Have you reviewed the medical examiner's autopsy report
Yes,
and the toxicology report that's part of that?
yes.
What did the medical examiner identify as the cause of death?
Drug intoxication with the specific drug being fentanyl.
I'm going to now ask you, Detective, some questions about someone with the initial CL. Do you know who I'm talking about when I say CL?
Yes, I do.
Who is CL in relation to the defendant?
CL is an associate of the defendant. She cleaned houses for the defendant's business as well as her personal home at times.
Does CL have a criminal drug history?
Yes.
Is she under supervision in a different county, a county other than Summit County?
Yes, she is.
And is that in relation to certain drug charges?
Yes.
Does
So, Chat, when you were talking about whether they found the person who got her the
which
fentanyl,
she's in, monitor treatment and testing, et
That-
cetera?
Yes.
might be the person who got her
Do you
the
know
fentanyl.
how CL is performing in that program?
Based on my interactions with CL, she is progressing through the stages of that program, and that her personal outlook on her recovery is optimistic.
Have you interviewed CL in connection with this case?
Yes.
Approximately how much time have you spent interviewing her?
Over the course of multiple interviews, several hours each, I would say upwards of 10 hours.
This is what the Kohberger attorneys
Was
don't
CL
want.
in,
What the Kohberger attorneys are fighting is exactly what's happening in this court. That while we've got an attorney questioning a detective, that we've just got to zoom in on the defendant's face. This is exactly what they're arguing there.
custody when you interviewed her?
Yes, she was.
Was that interview captured on video and audio recording?
Yes.
What, if any, promises did you make regarding, or to CL regarding her cooperation with being interviewed?
CL was not made any specific promises, but at the outset of our interviews, we explained to her that her cooperation in our investigation would result in us working with the prosecutors that were responsible for the charges she was facing.
Always. That's
Did you
almost
express
always
to
how that
CL
goes.
the seriousness of this case as well as the charges she was facing?
Yes, we expressed to her the seriousness of the charges and the possible results of those charges. As well, we impressed upon her the importance or the value of her testimony in this case as it related to
Right.
the
If
charges
you
that she was
cooperate with
facing,
us,
and that her testimony or any
it can
information
help
that she
you.
may have was more important to us.
Cooperate with us.
Did you stress to CL that the information you were asking her about needed to be credible and verifiable?
Yes, we told her at the beginning of our interview that any information that she may have, we would need to corroborate in order for it to be of value to us.
Did CL cooperate
That's
with
how,
being
this is exactly
Yes,
how
she did.
informant conversations happen.
Did CL know Eric Richins?
Yes, CL told us that during the time that she spent cleaning the Richins home, she got to know Eric, that she felt that he was a really good person, she liked him, and she was very saddened to hear that he had passed away.
Did there come a time when investigators executed a search warrant on CL's home?
Yes.
Also,
In
if all of
executing
you are asking, how is this detective saying what other people said, those rules of evidence don't apply because it's a bail hearing.
that warrant, did you make any observations consistent with CL's testimony that she felt bad about Eric Richins' death?
Yes. Inside the home, we identified a bedroom that belonged to CL. In the bedroom, there was a mirror above a desk. On the mirror were taped or affixed several inspirational quotes that seemed to relate to her recovery and her drug court program. Amongst all those inspirational quotes was a newspaper clipping of Eric Richins' obituary.
Huh.
Did you get the impression that part of the reason CL cooperated is because she felt bad for Eric Richins?
Yes, in fact, she said so many times in our interviews.
Huh.
Detective, I want to turn now to what, if anything, CL told you about the defendant requesting that CL purchase fentanyl for the defendant. What did CL tell you?
In our interviews, CL told us that in early 2022, the defendant reached out to her either by phone call or text message requesting that she procure fentanyl for what the defendant reported was an investor who had a back injury.
And upon the defendant asking CL,
The
Get
defendant
fentanyl,
is
what did
a
CL do?
realtor, is my understanding.
CL told us that she reached out to an acquaintance of hers, acquaintance one, and requested that she introduce her to somebody that could sell her fentanyl.
Yeah, this might be why there's
did
distribution
acquaintance
charges.
one introduce CL to someone that could sell CL fentanyl?
Yes, CL said that acquaintance one provided her with a phone number of another acquaintance, acquaintance two, who was someone that she knew could sell CL fentanyl.
And did CL say that she ultimately contacted acquaintance two?
Yes, she did.
What, if anything, did CL say about purchasing fentanyl from acquaintance two?
CL told us that she contacted acquaintance two after receiving his phone number and asked to arrange to meet to purchase some fentanyl from him. She stated that sometime in February, she believed she met up with acquaintance two at a Maverick gas station in Draper and purchased from him 15 to 30 round green-blue pills, which she understood to be fentanyl.
Using phone records through the course of your interview with CL, were you ultimately able to narrow down on what that date was in February that CL purchased fentanyl from acquaintance two at the Maverick in Draper?
Yes, based on
So CL middleman
forensic evidence, we
the
were able to
fentanyl
determine that date
purchase.
was February 11th, 2022.
between Richins and
What, if anything, did CL
The,
say about what she
acquaintances.
did with the fentanyl pills that she purchased from acquaintance
sounds
two?
like she sold them.
CL told us that after purchasing the pills from acquaintance two, she returned home to her house in Heber. She said that either later that night or the next day, the defendant met her in the driveway of that home and did a hand-to-hand exchange of pills for cash.
I'm going to turn now, Detective, to some questions regarding witnesses who corroborate CL's testimony, okay?
Okay.
You mentioned acquaintance number one. Have investigators interviewed
Did they find the
one?
acquaintances?
Yes.
Oh,
Have you
okay then.
reviewed body camera, audio, and video of that interview?
Yes.
Does acquaintance one corroborate CL's testimony?
Yes.
Well, that's helpful.
She stated that CL contacted her in early 2022 and asked for someone that could sell her fentanyl. In the body cam, she also retrieves her cell phone and shows investigators the messages that corroborated that.
And what kind of messages were they?
They were messages between acquaintance one and CL on Facebook Messenger app.
And have you reviewed those messages?
Yes.
Is the first of those messages dated February 6, 2022 at 1:37 p.m.?
Yes.
Does it read, text me, I've got a question, won't do it on this?
Yes.
And that's CL writing acquaintance one, asking acquaintance one to text CL because she didn't want to write over Facebook Messenger?
Correct.
Did acquaintance one say whether or not she ever, in response, contacted CL?
Yes, she said that she then either texted or called her subsequent to her request.
You testified that acquaintance two sold fentanyl pills to CL at the Maverick and Draper. Have investigators interviewed acquaintance two?
Yes.
Have you reviewed body camera audio and video of that interview?
Yes, I have.
Is acquaintance two able to
Wait,
corroborate?
Lee, what are we
CL's
doing?
testimony?
Stop.
Yes,
I don't need to know
acquaintance
this
two was able to
man's
recall that he
eyebrow
sold
grooming
fentanyl
pattern.
pills
Can we
to a friend of acquaintance one's
what is
in
that?
early 2022
camera?
at a Maverick gas station in Draper.
Can we zoom back out,
I'm
please?
going to turn our detective to some
Just show me the
forensic
courtroom.
data questions and whether forensic data corroborates CL's narrative, okay?
Okay.
Have you reviewed carrier records of the defendant's phone?
Yes.
And I want to just clarify one thing. I'm talking right now about carrier records, different than cell data records. We'll have an expert testify about cell data records in a moment. I'm just going to ask you about the carrier records, okay?
Okay.
I love cell records.
What, if anything, do the carrier records for the defendant's
I'm
phone,
actually more interested in her
what,
eyebrow
if anything, in
grooming
the carrier records
habits.
for
I mean, her
defendant's
eyebrows
phone
are on
corroborate
point.
CL's
But
testimony?
still, can we zoom back
The-
out and show the courtroom?
The cell records from the defendant's phone show several phone calls back and forth between her and CL in early 2022.
Do they show any text messages back and forth between the defendant
Yes,
and CL?
distribution
Yes,
is on the indictment.
Have you reviewed those text messages?
We were only able to see the timestamps and who the sender and receiver was. We're not able to see the content of those messages because they appear to be deleted from both the defendant's phone and CL's phone.
All right. Text messages that were deleted. Unpopular opinion. What does this testimony have to do with bail? Part of the argument with bail is going to be that there's either not enough to connect this defendant to the crime, there's not enough to hold them, they are entitled to bail, they're not a danger to the community, blah, 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 blah. So the testimony shows the court, no, this is everything that we know. This is why they should be held without bail. Gray, that's not new at all.
Have you reviewed the call history and carrier records of CL's phone?
Yes.
Call history and carrier records are
Does CL's carrier records and call history
going to
corroborate
get you there.
CL's testimony?
Yes.
Let's try to pull.
Is
Yes.
there a particular set of calls on February 11th, 2022 between 5:19 p.m.
I just need to know if he has a beard or
6:52
not
p.m. in CL's phone
at this point. I think he
Yes.
did.
Question CL regarding those calls.
Yes. She said those calls were to acquaintance two and that they were to arrange the specific date and time to pick up fentanyl in Draper.
Turning now from CL's purchasing fentanyl for the defendant to the defendant's purported timeline on the night of Eric Richins' death, okay?
Okay.
You mentioned earlier that police interactions with the defendant were captured on video. Have you reviewed that video?
Yes, I have.
Huh.
Did the defendant provide police with a written statement in the
So
early
defendant
morning
talked
of
to
March
police.
4th, 2022?
Yes,
That'll
she
be
did.
interesting.
Have you reviewed that statement?
Yes.
What on the early morning of Eric Richins' death did the defendant report had happened that evening?
She stated that the last time that she saw Eric alive was between 9:30 and 9:45 p.m. She stated that before going to bed, they had had a drink together to celebrate closing on a house for her business. She said that they got
Realtor.
in bed between 9:30 and 9:45, and that shortly after getting into bed, one of the children had a nightmare, and that the defendant got out of bed and went to be with that child in their bedroom and slept in that bedroom until 3 a.m. or around 3 a.m. when she woke. She stated she returned to her own bedroom, got into bed, and felt that Eric was cold to the touch. She stated that she turned the light on, saw that he wasn't breathing and that he didn't look normal, and that she then called 911.
Did the defendant say whether anyone else was in their home other than the defendant,
And
her
their
husband Eric
children?
Richins, and their 3 young children?
No, she stated no one else was in the home.
Turning now to the defendant's statements regarding whether she performed CPR on her husband, okay?
Okay.
Oh,
Did the defendant tell investigators when they arrived at her home
On the bed?
shortly after she called 911 whether or not she performed CPR on Eric Richins?
Yes, she reported that she did.
Well, depending on what
I'm going to refer to
EMS
someone now
did.
as defendant's best friend.
That's
You know who I'm talking
interesting.
about.
Yes.
What, if anything, did the defendant tell her best friend regarding whether she performed CPR on Eric Richins?
Investigators found text messages between the defendant and her best friend that was her explanation to her friend that she conducted CPR on Eric prior to EMS arrival.
And do those text messages
I imagine this
read,
is coming up because
"I
they
pumped
don't
so
believe this
damn
is
hard,
true.
So hard, screaming at him to come back to life?
Yes.
I imagine if they believed this was true, this wouldn't be coming up.
You testified earlier, Detective, that EMS responded. Have you interviewed the first EMS responder?
Yes, I have.
What observations did that EMS responder make?
They told me that when they arrived, they began CPR compressions on Eric.
Okay.
And that upon
The dramatic
beginning
extreme
those
close-ups are
compressions,
too
Eric
much.
began to foam at the mouth. He stated that that
Oh.
observation indicated that
She didn't
CPR
do
was not likely
CPR.
conducted before he arrived.
No, that she didn't do CPR at all.
Detective,
Why-
as part of your investigation,
We have learned in the Murdaugh case how one lie to police can unravel everything. So if she lied about doing CPR, EMS is going to be able to say, well, she didn't do CPR, among other things. Laura M., is this the same courtroom as Paltrow? It's the same courthouse. I don't know if it's exactly the same courtroom, different judge.
did you look into whether Eric Richins used illicit drugs?
Yes.
What did you determine?
Based on the interviews that we conducted with those who knew Eric well, all stated that he did not use illicit drugs other than consuming THC gummies on occasion.
Which is probably illicit in Utah, right?
Those that you spoke to include Eric's two best friends that he's known since high school?
Yes, both made the same statement that they never knew Eric to use any illicit substances other than the THC gummies.
When I reference a hunting guide in Mexico by the initials
I've been attacked by these camera angles. Oh my God.
TR, do you know who I'm referring to?
Yes.
Did you speak to this hunting guide?
Other Summit County detectives did, yes.
And what did this hunting guide, if anything, say about Eric Richins using illicit drugs while hunting in Mexico?
The guide told detectives that several of their clients, when they come to Mexico, will seek out someone that can put them in contact with illicit substances while they are down there for their hunt. He stated that Eric Richins was not one of these, that Eric was solely focused on the hunt.
Hunting combined with drugs sounds
Has
like
the
a bad
defendant made any
idea to me.
statements regarding whether her husband, Eric Richins, used illicit drugs
Maybe it's
other
me.
than THC?
Yes, in several statements made by the defendant throughout the
I mean, it
investigation.
does look a lot like the Paltrow
There have been at
courtroom.
least 10 times that she has said that Eric
Oh, there's
does
Chandler
not use
Painter.
illicit substances and did not use illicit substances.
The reason they're talking
And
about
just to be
the deceased victims, God, this camera's killing me. The reason they're talking about the deceased victims' use of illicit substances is because they are trying to show, or they will argue at some point, that this was not an accidental overdose. That is the point.
clear, other than THC.
Other than the THC gummies, correct.
Notebook.
On the night Eric Richins died, did investigators search the Richins home?
Yes.
Did they find any illicit drugs?
No.
Did they find any paraphernalia or packaging or other evidence of illicit drugs?
No.
Did they find fentanyl anywhere in the home?
Only that which was in Eric's body.
So no fentanyl in the home.
I'm going to now shift, Detective, from
Which again,
the night of Eric's.
when you look at locations where people have accidentally OD'd, you normally see what they have taken also near them. And you normally get an idea of what they're taking, because accidental ODs normally, like, they didn't have a chance to clean it up. They accidentally OD'd. So you normally get that. You normally see that. So Blair Witch Court Edition, it feels like it is killing me.
Death to a second drug buy initiated before his death and concluded after his death, okay?
Okay.
Yeah, Cheryl, I think that's probably what the
What, if
defense will
anything,
be
did
here.
CL tell you about the defendant approaching CL a second time for fentanyl?
However, then why
CL told
lie?
us that approximately a week after delivering fentanyl, the defendant reached out to her again by text or call and said that she wanted some more fentanyl that was stronger than the previous batch.
And in response, what, if anything, did CL do?
CL told us that she again reached out to acquaintance 1 because she had lost the phone number for acquaintance 2, and again requested from acquaintance 1 that
More
she
fentanyl?
provide her with the phone number for acquaintance 2. She also made other statements in Facebook messages regarding that request.
All things that are easily trackable.
In your interview, or detective's interview rather, with acquaintance 1, did she corroborate that indeed CL reached back out to her asking for acquaintance 2's phone number?
Yes, in the same Facebook Messenger, it showed the 2 different contacts on the 2 different dates.
And does the second Facebook message, was it dated February 25th, 2022 at 9:40 p.m.?
Yes,
And does it read, "I need those again, but more, and I don't got a ride, I lost your friend's number"?
correct.
Yes, this is the woman who wrote the children's book about grief.
Did CL and acquaintance 1 both say that acquaintance 1 provided CL with acquaintance 2's phone number again?
Yes.
What then, if anything, did CL do with acquaintance 2's phone number the second time?
CL told us that she again contacted acquaintance 2 and arranged again to meet up at the same Maverick gas station in Draper to purchase again 15 to 30, this time blue round pills that she understood to be fentanyl.
On the way to the Draper and Maverick, the second time, when she purchased 15, I'm sorry, did you say 15 to 30? What-
Yes, 15 to 30 pills.
Which she believed to be fentanyl. Did she make any stops along the way?
Yes, CL told us that the second time that she procured fentanyl
Oh my God,
for the defendant, she did not have a vehicle to drive on that date. She said that she reached out to a friend, acquaintance 3, and asked that he give her a ride to go purchase fentanyl. She said that he did pick her up, that they traveled from Heber City to the defendant's home in Francis, where, according to CL, the defendant had told her there was a check waiting under the mat at the defendant's home. She said that she checked under the mat and didn't find a check, and so she knocked on the defendant's door, and the defendant came to the door and wrote her a check from her business, from the defendant's business, for $1,300 for the purchase of the fentanyl.
You're buying
CL told
fentanyl
us
with your
that
work checks?
Afterwards, they
She doesn't agree with that.
drove
You
to
saw
the
her
America
face.
First Credit Union in Heber City, where CL banks, and cashed the check and deposited $300 of it into her account at America First Credit Union. She said that after stopping at the bank and getting the cash, they then drove to the Maverick gas station in Draper and purchased the pills from acquaintance 2.
Did investigators execute a warrant at the America First Credit Union in Heber?
Yes, and that warrant returned a copy of the check written from the defendant's business account.
The defendant's like,
in
yeah,
the
I wrote
name
the
of
check.
CL.
I imagine she thinks it was for
And
something
a receipt
else.
that shows that it was cashed and that $300 were deposited into CL's account.
I wonder if the defendant's going to say it was for cleaning
And then
homes
CL
to stage
ultimately-
them or something.
Being driven by acquaintance 3 went to the Maverick in Draper and purchased fentanyl a second time from acquaintance 2.
Correct.
What, if anything, does acquaintance 2 say that corroborates CL's testimony?
Acquaintance 2 in his interview stated that he remembered selling fentanyl to a friend of acquaintance 1's on 2 separate occasions at the same Maverick gas station in Draper. He also said that he remembered the second time that he sold her the pills that CL was with another person who matched the age and gender of acquaintance 3.
Have you interviewed acquaintance 3?
Yes.
What, if anything, does acquaintance 3 say to corroborate CL's testimony?
It's a lot of people
Acquaintance 3
selling
corroborated all the
drugs.
same details that CL told us about that day, and in fact showed us text messages on his phone that also corroborated that story.
Detective, I'm going to ask you now some questions about what are commonly known as bug-out bags, okay?
Okay.
Did investigators execute several search warrants on the defendant's home or the family home?
Yes.
A lot of people have bug out bags. What are we,
Did those
what?
warrants identify what are commonly known as bug-out bags?
Yes. There were several duffel bags stored in the garage, along with backpack-sized day packs. and each was identical and labeled for a different member of the Richins family. Those backpacks were seized subject to a warrant and were inventoried and photographed. Inside the bags, detectives located several items that would be useful in an emergency situation, but the most interesting were documents needed for travel for each member of the family. Each bag contained a photocopy of a state-issued ID in the children's case, along with passports for Eric and the defendant, as well as global entry travel cards for both Eric and the defendant.
Did those bags also contain clothing, toiletries, that kind of thing?
Yes.
Do detectives know when those bags were packed?
No.
What's that have to do with whether or not there is a murder?
And there was a bag for Eric as well, is that right?
Correct.
Lots of people have bug out bags.
I have no further
Okay.
questions for you. Ms. Lazar on mine. Thank you.
Interesting. Also, if you don't think that law enforcement will take everything and attribute it to this, then we're watching this. But the chat makes a good point because this is a bail hearing. Is this a person that is prepared to leave the country? Yes. Kelly, earthquakes very real in California, as are fires. So bug out bags are pretty normal. However, they are going to argue that she is prepared to run and didn't. But he also had a bug out bag and he is now deceased. So I don't think the bug out bags are much of a thing at all. I think it's just smart. We have tornadoes here. You have to be prepared for that. Her shoes are cute. Oh my God. Sir.
Detective, it's O'Driscoll, right?
Correct.
We like the defense attorney too, but sir.
Good morning.
Good morning.
I'm going to follow a little bit the same timeline just so we kind of keep things together. You said you reviewed the body cam that was provided on the night that Eric passed away, correct?
Correct.
Okay. And that Kouri made a statement that night to police, a written statement.
Correct.
Okay. And she told them that she had made a drink, correct?
Correct.
Okay, so they were aware of that. Was there anything in that body cam or investigation that talks about them looking for a glass that a drink had been made in?
No.
Okay. But you said that they searched for illicit drugs, correct?
I don't know if they searched for illicit drugs, but they searched the home.
Okay, so they searched the home that night knowing that he had a drink right before he went to bed and made no note that they had recovered glasses, looked for glasses, anything along those lines, correct?
Not to my understanding.
Well, why wouldn't they?
You also testified that when you interviewed CL, she was working on both a personal and, I'm going to say, professional capacity for Kouri, correct?
Correct.
And she was cleaning houses, that she was both cleaning Kouri's personal home, and then she would clean homes that were investment properties, correct?
Bing, bing, bing.
CL told us that she cleaned both homes for Ms. Richins' business, as well as at another time frame, she cleaned their personal home.
Which could make
So
the
not necessarily at the
$1,300
same
make
time.
sense.
But at the time, she was cleaning homes for the business, correct?
Which time are you referring to?
On or about the time leading up to or during your investigation, end of the year, end of 2021, beginning of 2022?
At that time, from my understanding of what CL told us, she was cleaning
Can we just
only
zoom out
investment properties
and
belonging
not try to read this woman's
the
mind?
Richins
I mean,
Realty.
I
And she
appreciate.
was getting compensated for that, correct?
Can we just
Yes.
see the
Okay, so
detective too?
the
I
check
know
that
we're
you issued the
capable.
search warrant on for the bank, that was written from Kouri's business account, correct?
Correct.
So it could very well be that Kouri was paying her for cleaning houses, correct?
I don't want to speculate.
Of course you don't,
It's fine.
Like what Phil
detective.
said, correct? Okay.
The detective
You
is
also
never going to
testified
speculate
that,
on behalf of the defense
CL was
and cross.
progressing through her drug court program, and you were optimistic about how she would do in it, correct?
Remember, with cross-examination, the questions matter more.
No, I testified that she was optimistic about her own
I'm
personal
sorry if I
recovery.
misstate that. How long were you investigating CL? When did you begin investigating CL?
I don't know an exact date, but the beginning of 2023.
Okay. And were you monitoring what she was doing at that time?
Yes.
Okay. because you knew she had a boyfriend or this guy in Vegas, some other details about her life, correct?
CL's the informant.
Set of investigating CL, no, we didn't know all those details.
But over the course of your investigation, you learned them.
Correct.
Did you have CL's phone,
Summit County Sheriff's Office evidence text too.
but you reviewed it?
Yes.
Okay. And you testified about text messages between CL and the defendant on or about this time period you're looking at in February, correct?
Correct.
Okay. Did you review any other information prior to that time about contact that CL and the defendant had had?
I'm unsure,
Did you even
but
look?
it's possible that we looked into communications. In this investigation, initial stages, we looked into communications with everybody that the defendant had been communicating with.
Okay. But you don't recall, or you didn't look for a pattern of communication between CL and the defendant, is that correct? You were focused on February?
I guess that depends on what stages of the investigation you're talking about.
I'm talking about any of them. Did you ever look and see if CL and the defendant texted each other about anything on a regular basis?
Yes.
Okay. And how far
And?
back did those go?
I'm not sure on exact dates again, but
He's like,
into.
we're here for a bail hearing. I don't have all
2021.
that.
Okay. So for a period of time, because CL is working for the defendant, there's communication, correct?
Correct.
And nowhere in the communication between CL and defendant, text messages asking for drugs, correct?
We didn't find any, but there were also timeframes in the phones when we looked at them.
Now, I want to also talk about, you said you didn't make any promises.
Correct, no
This
specific
feed
promises.
is
Okay.
tough, but we've seen that from Park City before too.
You did,
The
however,
feeds sometimes get fed a little choppy,
tell her,
depending on weather and such.
let me back up. When was the first interview you
I
had with
saw
CL?
that in Paltrow as well.
I believe it was April 28th or 26th. I believe it was the 26th.
Did you have any contact with her prior to that?
No,
Did anybody from law enforcement have contact with her prior to that?
not from our office.
You don't know if anyone else talked to her?
I don't.
Okay.
Well, they don't
Now,
know
part
if
of this
any law enforcement ever talked to her, ever. It's possible.
came out of a raid or something along the lines that was coordinated with at least ATF and some other agencies, correct?
CL's home was subject to a search warrant based on information that we had gathered during our investigation into CL.
Okay. And that search warrant would essentially contradict that she was doing well in what she was supposed to be doing in drug court, correct? She was buying drugs, wasn't she?
We didn't know that. We knew that she was associating with people that we knew had active
This was
warrants
from
for
Monday.
drug charges.
So maybe.
And that would be a violation of drug court conditions, correct?
From my understanding, yes, but I don't know the details of that.
Generally,
As part
buying
that
drugs
search
is a
warrant,
violation
were,
of drug court conditions.
Individuals arrested?
So,
CL was arrested, yes.
There were other individuals who were arrested too, correct?
I'm not recalling other individuals that were arrested on the date that the warrant was served.
Okay. Were any drugs recovered at the home?
Yes,
Okay. And you also recovered a firearm from CL's bedroom, correct?
correct,
And that would be a violation of her drug court conditions, correct?
correct.
Okay. Now, in this first interview in April, you begin the interview. Give me a moment here to find the right notes. By explaining to CL essentially how dire of a situation she's in, correct?
I don't have the interview memorized, but I know we talked about that, yes.
Okay, well, you told her that she was on probation to drug court for 4 first-degree felonies, correct?
Correct.
Okay, a violation of that is a potential prison sentence, correct?
It would depend on the prosecutor, but that's potentially true.
Okay, a first-degree felony carries a possible penalty of life in prison, correct?
wait,
I don't know, I would have to reference the code.
all first-degree felonies in Utah carry the potential of life? Really?
So you told her she was facing problems with that, correct? That
Correct.
this would be a violation. So she'd be on the hook for 4 first-degree felonies.
Potentially, yes.
Okay. And
The defense is getting at in cross-examination that CL, the informant, would kind of say anything because they want to lessen the seriousness to them. It's like, well, wouldn't CL just try to save their own ass?
you also told her that having the firearm
That's going to make it
potentially
worse.
be a new crime, correct?
Yep.
Okay. And then you also told her that the U.S. Attorney's Office was essentially on board with screening drug distribution charges, correct? I'm happy to play it if you don't remember.
I don't remember specifically.
Do you remember talking to her about potential federal charges?
Yes.
Okay. So she was aware that not only was she facing multiple first-degree felony prison sentences, she was also potentially facing federal charges, correct?
Correct.
And during that initial interview, she tells you that she didn't buy fentanyl, correct?
I don't know if she made that specific statement, but she talked about not knowing anything about fentanyl.
Okay. And that interview lasted about an hour and 19 minutes, hour and 20 minutes, correct?
Correct.
Okay. And that interview ends, well, with you telling her, sometimes you tell her to think through all of this and let you know if she wants to help.
That sounds
Yes,
about
I
right.
gave her the opportunity to tell us up front whether she was willing to cooperate or if we should just not bother interviewing her anymore.
Sounds about right.
But this is after you essentially tell her that she has the potential of doing a considerable amount of state and federal prison time, potentially.
Yes.
Yeah, I
It's a
don't doubt that
common
at all.
tactic in law enforcement to be able to leverage charges for information.
Okay. In fact, you did in this case
He's
leverage
like,
charges for
"And that's
information
how it
because
works."
you told her that you didn't care about first-degree felonies or federal charges. What you cared about was information about
I told her that I was interested in the information that she may know about this case.
Okay. But you told her also that Eric died of a fentanyl overdose, correct?
Correct.
And you told her that you thought that Kouri gave him the drugs, correct?
I did not specifically say that.
You alluded to the fact that you needed information about Kouri getting
Remember,
fentanyl
this
because
is
that's how Eric died.
cross-examination. Law enforcement answers are going to be as precise and narrowly tailored as they can be, which is why you're going to see these very narrow snippets of answers and her doing a good job cross-examining and saying, yeah, but this. So I like her cross-examination style. I'm not surprised that the officer is like, well, and then they're going to narrowly tailor it. That's cross-examination.
Right, correct.
I don't know if I made that specific, but the information that we tried to convey to CL was that we wanted to know the
CL, you're in
information that she
deep
may
shit.
have regarding Eric's death.
It's going to get better for you if you
And-
tell us what you know. That's what they wanted to convey. That's exactly what they wanted to convey. That is what they do.
You didn't care about any additional charges. All you cared about was that information, correct?
He doesn't get
As
to
I
decide
said
to bring the charges.
Previously, we
He's not
expressed to
prosecutor.
her that the information that she may have was more valuable to us than seeking charges against her.
They're more interested in information about the murder than they are in information about.
And then you interview her
The
2 more
drugs.
times. Is that right?
No,
Okay.
there were, I believe, 3 more after our first one.
Okay. Were all of those audio and video recorded?
4 interviews
Yes.
with CL.
And those were turned over to the state in this case, correct? The state being the
Correct.
prosecutor's office? Okay.
Which means you should also have them.
Now, forgive me because with all these interviews, I'm not sure which one comes from which.
Also fair.
You, in
It's a lot of
subsequent
information to
interviews,
review quickly.
tell CL that she needs to give good enough details that will ensure that Kouri gets convicted of murder, correct?
I don't know if I made that specific statement, but I did express to her that the information that she gave us needed to be specific enough that we could corroborate it and that it could be presented to a courtroom.
Okay. And that she was, quote, screwed at this years if there's not cooperation, correct?
No, I never made such statement.
Okay.
Really? Because I can totally see law enforcement being like, so you're fucked. Do you want to do something about that? So,
Did you ever tell her this was her get out of jail free card?
No, I did not.
That would be distasteful. Michelle, yes, this is a bail hearing.
Yes.
So, is it necessary for her to be handcuffed? Yes. At this point of the proceedings, this court's
No,
going to
at some
determine that.
point, CL
These are contentious
tells
proceedings.
you that in one of the interviews that Kouri
Empress,
contacted
that's
her
rad.
between December
Say
and
hello
February
for me.
to obtain prescription pills for
I
an
enjoyed
investor,
working at
correct?
CCB.
Correct.
Okay. And she doesn't specifically state fentanyl at that point, correct?
Are you referring to CL?
I'm referring to CL.
I don't remember, but I don't believe so.
Okay. And in fact, and I'm guessing it's something where around the second or third interview, CL says that those first pills, well, never says those first pills are fentanyl, correct? It never says that Kouri asked for fentanyl, correct?
That's two questions.
I'm sorry, could you rephrase the question?
In those first, in the first transaction, so initially, CL tells you that there were 3 transactions prior to Eric's death, correct?
Yes, and what I have to say here is that
Well,
none
that
of,
was a yes or no question.
but none of the information that we got from CL was perfectly chronological. We had to piece it together over multiple interviews to come to the conclusion we came to.
Because you told her you needed something more specific to ensure that Kouri gets convicted, right?
No, we told her that we needed more details
So
on
we
what
could
she was talking
corroborate it.
about and specific dates and times.
Okay. But in the first,
She's going to, CL's a liar trying to get herself out of deep shit. And didn't you, law enforcement, feed it to her? And the detective's like, no, we were trying to pull information out of her so we could corroborate it, which is kind of how working with informants goes. Generally, the informants that are super forthcoming are lying, and they're like, let me tell you everything. Informants that are reluctant tend to be a bit more reliable, just in my experience, because they're torn. They're torn about turning on people. Different than like federal white collar crimes. I'm talking about your kind of state criminal crimes. I mean,
when she says there's 3
more
transactions
violent
prior
crimes.
to Eric's death, correct?
At some point in our interviews, she told us there were transactions.
And she says that Kouri was only looking for prescription pills or hydrocodone pills, to be specific, correct?
CL referred to them as Roxy's.
Okay. What do you know Roxy's to be?
Oh God. Back to
They can be different things
Roxy's.
in the drug world. They can either be counterfeit pills that are meant to look like a prescription pill, or they can be actual prescription pills. But generally, they're known to be opiate-based drugs, whether
We
illicit
all
or
watched
pharmaceutical.
Depth for
So
Her.
something along the lines of hydrocodone or
We know-
Oxycontin or something along
We
those
now
lines,
know a
correct?
lot about
It
what
could be.
Roxy's are.
And she specifically says that she was looking for $900 worth of fentanyl pills, correct?
I don't know if initially, but she did make the statement of $900 at one point in one of our interviews.
Okay. And she says that Kouri told her to leave the pills at an outdoor fire pit at the Midway house where there was cash, correct?
I don't know if she made that exact statement, but yes, she told us that at some point in part of the exchange that she was instructed to leave pills in an outdoor fire pit in a house in Midway.
Okay. And in fact, you sat there with her in this interview and did house searches, correct? Trying to figure out which house this was.
Yes.
Okay.
Okay.
Because she couldn't really tell you which house it was, correct?
She couldn't give us an address, but she was confident that she could find it if she could drive there.
Okay.
Me.
And did you
That.
take
Why
her
is
for a
that
drive there?
me? Why is that me? Which house? It's like I could drive you there, but I can't tell you the address.
Yes.
Did you ever do any follow-up investigation on whether or not that house ever sold?
Yes.
Okay. And you know that that house sold sometime in January of 2022, correct?
What I understand, yes.
Okay. So Ms. Richins no longer
Chat,
owned that
all of you are
home
like,
or
"It's me."
occupied that home or had access to that home in February, correct?
I don't
It's a
know.
good question. You don't know if this defendant even had
The house was
access
owned
to
by
that
somebody
home.
else, right?
Again, I don't know.
Well, you said it closed in January of 2022.
From the
Good question.
information that I was told from other people, other investigators that had looked into that, I was told that Ms. Richins owned the house at some point and that it sold at some point. I don't know dates exactly.
Be important if CL's telling you that she had access to the home and was there in February?
Yes, it would be important.
That might be a good fact to know.
Yeah, it sure would. Agreed. Uh-huh.
Okay. CL then does subsequent interviews, correct?
Yes, we had multiple interviews with her.
Okay.
It's a good point. If CL's saying I left drugs at the house and the house is sold to somebody else.
And after being told that, as your words are, correct? She now says that it was specifically fentanyl that Kouri asked for, correct?
Correct.
And that she didn't actually take the pills to that house in Midway. It was a hand-to-hand transaction, correct?
Like I said, she went back and forth on her memory on which instances referred to which transactions. And ultimately, she told us that she was sure that the first transaction of fentanyl was a hand-to-hand transaction in her driveway.
Okay. And was what's been referred to as acquaintance 3, was that in regard to that transaction?
No,
Okay.
it was the second transaction.
Were you able
Oh
to
my goodness.
corroborate, was anyone with her that could corroborate that she saw CL hand Kouri drugs?
Not that I know of.
And then she states that now there was
McLinda, yep, that was a very intentional
a
use of.
transaction.
her memory
that
was
occurred
not great.
After Eric's death, correct?
She didn't make the statement that it was after Eric's death, but she told us there were
However, I
three total
don't
transactions.
think,
So the information contained in the state's amended information, you don't know where that came
this is
from?
a piece of the evidence.
Which information are you
That
referring
she
to?
This is not
purchased
all of
drugs
the
after
evidence.
Eric's death?
Yes, I do know where it came from.
Okay. And you're saying CL did not sell drugs to Kouri after Eric's death?
CL could not remember specific dates and did not make mention that the transaction happened after Eric's death. But when presented with digital evidence from other witnesses, she confirmed that that was most likely correct.
Digital evidence.
So she just agreed with your scenario of events, correct?
No, in fact, several times during our interview, she told us that as we presented her more information, it helped her remember more.
I mean, that's,
So as you're telling her
Awesome.
to be more specific, you're providing her with information
This is a
that
good
you're
point.
gaining in, and she's saying, now I remember.
oh, yes,
Accurate?
now. It makes it seem convenient. She knows that's a great question. Look at her. She's trying not to smile too much. She knows that's a great question. She's like, that is a good cross question. So, but that's not uncommon when people are presented with digital
Also
evidence that they go,
testified
oh, this
you
or that.
Interviewed 2 of Eric's best friends, right?
Because
Yes.
the digital evidence doesn't
And-
lie.
During one of those interviews.
I look forward to the cell phone guy. I also might speed this up. I think we could go a little faster. If this gets horrible, I'll slow it down. This is a bail
Let me go
hearing
back to-
decided by
to
the
CL for
judge.
just a second. On this transaction that you
that's
allege
too
that this
fast.
check was used for, or the state alleges this check was used for, you testified that she picked up the check, there was
Yeah, that's too
on
fast.
cash.
Sorry.
it, right?
Correct.
And drove to the Maverick and purchased fentanyl.
She didn't drive, but she was.
Someone drove her,
Yes.
okay?
Yep.
And
This is a
and
bail
the
hearing
person with
decided
her
by the
corroborates
judge.
that.
Correct.
And
Look, chat, hear me. Autumn, you raise a great point. If somebody says, do you remember? Do not fill in the I remember. Say, I am not good with dates or times. So if you could give me my phone, I could show you, but I don't remember. It's okay to say, I don't know. The thing is, the person they're talking to, CL, has a whole bunch of narcotics charges pending, it sounds like, for distribution. And so the defense is saying the police were like, hey, you're super screwed, but we need information on this. So if you can provide us with specific information that we can corroborate, then it's going to go better for you. And the prosecution said, well, no, they didn't quite say it that strongly, but they did. This is an informant that is trading information to get a better deal. That's exactly what it is.
that third witness never saw CL give those drugs to Kouri, correct? Acquaintance 3 never saw that?
Acquaintance 3 didn't tell us that he ever saw that, no.
Okay. In fact, there's no independent witness to corroborate that CL gave Mr. Kouri those drugs, correct?
And that's a problem, if that's true.
no eyewitnesses that we have identified, but the investigation is ongoing.
Yeah, it's early in the investigation.
And CL is currently out of custody, right?
Depends on your definition of custody, but she's not incarcerated. No.
Oh, she's in a drug
Not incarcerated,
program.
just on, I think, ankle monitor and not to leave the county, right?
Oh.
But following your
Ankle
interviews
monitor.
with her, she was released from jail.
Not immediately, no. She worked with the prosecutor in the other county where her drug court is and came to a resolution as to those charges against her. And part of that was being released on ankle monitor.
Okay, so in exchange for the testimony, or not testimony, in exchange for the information that she
Information.
provided to you, and a deal was worked out where she was placed, essentially released from jail on the order to show cause, correct?
I don't know the specifics of what went on between the prosecutor and CL,
Okay.
but subsequent to our interviews, we reached out to the prosecutor's office and let them know that she was being cooperative. After that, I was not involved in any decisions regarding her release.
Okay, because that's up to the judge and whatnot.
Correct.
But you did communicate that to prosecutors?
Yes.
That she gave you the information you needed?
That she was being cooperative with our investigation, yes.
All right, I'm going to turn now to your
Yeah.
interview, and I'm going to...
She's not in jail. He could have said she's on an ankle monitor and out
an
of jail.
interview with
This is
one of Eric's
cross-examination.
friends. His initials are JS. Do you recall that?
CL is
That
definitely
interview occurred
cooperating
about
at this
April
point.
20th, is that correct?
That seems right. I don't know a specific date, but
Okay. And during that interview, he discussed, or you discussed with him, that he and another individual were essentially Eric's best friends, correct?
So Sarah, my apologies.
Yes.
April 20th of which year?
Oh, 2020.
That was the judge.
I apologize.
Thank you.
Attorney Lucero, I believe.
At any point during that interview, did JS mention that Eric had said that at any point during he and Kouri's marriage, he was concerned that Kouri was attempting to poison him?
I don't recall, but I don't think so.
In fact, you present him essentially 3 scenarios of what could have happened to Eric, correct? That he essentially did it to himself knowingly, that someone else did it to him,
So,
or
Lazaro.
that it was accidental, right? And you specifically ask him if he thinks Kouri would have done it, and he says, no, in my gut, I don't believe so, correct?
I don't know if that was a direct quote, but yes, he said that he didn't believe that she would have done it.
And he also states during that interview that at the time of his death, Eric and Kouri's marriage was in a really good place.
Yes.
correct?
According to his best friend.
Now, he also details or talks about a falling out that he and Eric had had over the course of their friendship, correct?
Yes, that sounds familiar.
And that Eric and his other friend that he refers to in this interview actually had a falling out right before Eric passed away, correct?
Yes.
You also talk
Jennifer,
about...
you just have to find what your brain retains. My brain
He talks
retains
about the fact that
facts and stories and song
of them
lyrics
at
and
different
stuff that I
times that had
hear.
marital problems, that they had helped each other through, correct?
So my brain retains this
JS
stuff.
told
other
me
stuff.
that he and Eric
This is
and
the friend.
their other friend would confide in each other about their marriages and would share information, and that was how he had the insight that he had into Eric's life.
He also talks about that Eric changed or created these trust documents, correct?
Correct.
Okay. And his understanding, based on what he said that Eric told him, was because Eric was pissed or upset about a relationship that Kouri had, correct?
Oh,
Or he thought she had.
I don't remember the specifics of that part of the
Detective.
interview, but I do remember that JS was aware that Eric had made the trust.
And he doesn't specifically say anywhere in that interview
detective, if she's stepping out, I think that's information that you want to know. If the husband is making a trust because he thinks that she's cheating, that's really pertinent information in a murder investigation when there's an affair on the table. Detective. I have questions.
That the trust was made because he was mad about this home equity loan, correct?
JS expressed to us that he understood that the reason that Eric created the trust was to ensure his son's well-being if anything were to happen to him.
And he also expresses to you that because you asked him why it wasn't changed back, or because the sister was made the trustee, correct?
I'm sorry, I don't understand the
The
question.
sister, so in the, that was a terrible question. In those trust documents, the sister was made the trustee.
I like this
correct?
From
attorney.
what I understand, yes.
And you asked JS specifically, or somewhere along the lines of, if they were doing so well, why would he have not changed that back?
Yes.
Okay.
The
And
trust
he
is in the
tells you,
sister's name. That's
that
interesting.
it was
We'll
his
hear more
way
about that,
of
I'm sure.
ensuring that even if they were doing well at the time, if there was a divorce, he would get the last word in it, right?
I remember him using that phrase, getting the last word, yes.
Oh. So the best friend of the husband said the trust was to ensure if they got divorced that husband would have
You
the last
also
word.
testified today about this hunt that took place
In Mexico.
down in Mexico, right? Correct? And this hunt
Did he answer?
was
He must have nodded.
February of 2022, correct?
I don't think your shoes
I
are
don't know specific
gold.
dates, but I'm aware
I
that
think
Eric
they're
was
kind
on
of
a hunt in Mexico
nudish,
shortly before his death.
And JS tells you
but it's hard to tell because
that he was
courtroom is
really upset,
difficult to
actually
film.
leading in the days right before he passed away about what had happened with this hunt, right?
Yes.
So the deceased
And,
husband's mad about the hunt?
He was upset that they had paid an outfitter for a number of permits that they believed the outfitter had procured, correct?
Yes, from what I'm recalling, he was upset about the outfitter or the guide had not gotten enough permits for the amount of animals that they ended up taking, and it caused some concerns over legal
like
requirements
nude-ish.
of tagging animals.
They're a neutral. I like
And
them. They
getting
look
the
painful,
cape or
but I like
anything
them.
else, correct?
I will not wear them.
And this is the same,
Yeah, it could be the
is
same
this outfitter the
courtroom.
person that you investigated?
Look, most of the courthouses I worked at, the courtrooms looked exactly the same, other than sometimes they were flipped with the jury box on one side versus the other side, depending on the hallway, but they looked exactly the same. So whether it is the exact one, I don't know. It could be just, it's in the same courthouse as the Paltrow case. But
Or that you
courtrooms often
interviewed?
look
Someone
identical.
associated with that hunt and that outfit, yes. I'm not sure the
Different
exact
judge.
association, but a contact for that outfitter.
Okay. So that outfitter was aware that they had made some serious problems for Eric with regard to how many animals they took in Mexico, correct?
According to JS, yes.
Okay.
And in your subsequent investigation,
I mean,
Eric
the
had
cross-examination's
had,
bringing the tea. I'm here for
some
it.
heated conversations, actually, the night
Finish my
before
coffee.
he passed, or the night that he passed away with that outfitter, correct?
We received information about that, yeah.
Okay. In fact, he was searching how far it was to drive from Scottsdale down there.
Oh, A
correct?
for adventure. The sister testifies at this hearing.
His phone showed that search.
Okay.
We'll talk about
And
that.
JS also told you that he had information or believed that this outfitter was somehow connected to the cartel, correct?
I don't recall. That sounds familiar, but I don't recall if those were the words that he used.
But essentially,
JS made a statement about the cartel when he was talking
Interesting.
about Eric and that hunt, yes.
Counsel, would you approach for a minute?
Yes.
Why are we talking about the cartel?
No. Will you turn the white noise on?
I'm going to speed this up.
1 second.
They turned the white noise in the courtroom on to have a sidebar. So I'm turning it down. Jeez. I am not loving the camera angles. This is the kind of shit that judges are complaining about in other courts. Zoom just out. They're putting on the white noise. The white noise is off.
We're going to take a break. Do you mind clearing the gallery first, and then we'll reverse the process all the way back.
They're going to break. All right. I'm going to...
So, ladies and gentlemen, I need to handle an issue with some members of the media that are live streaming without permission to do so. This is a good opportunity to take a restroom break.
Oh, shit. Ladies and gentlemen, I am going to deal with some issues of members of the media live streaming that shouldn't be.
Reverse the process we used on the way in. If the gallery would please follow the deputy's instructions, proceed orderly on the way out. If you let you stretch your legs, we'll come back in about 20 minutes. Thank you. Now. All right.
Okay, so while they file out, I'm going to speed this up. I want to see if the court addresses this on the record in a way we get to see. Oh boy. No, we're not, Olga, we're not in trouble. We're, hold on. Now they're talking. I want to hear what they say. This is just supposed to be live streaming to a pool camera, it seems. But the court said that so fast I didn't hear it. The closed caption picked it up.
The word is KUTV and Court TV are live streaming. I think they're live streaming it separately. I can clarify, but...
They're talking about KUTV and Court TV both live streaming. This was live on Monday, so they're trying to figure it out. They should have assigned a pool camera.
ABC4 has the signed order. Yeah, KUTV and Court TV do not.
Huh. So only one outlet has a signed order to stream the proceedings. Others do not.
Folks in the jury boxes, kind of feel like you're okay.
So there was not
You're
a
okay to have a seated play.
there was not a pooled camera.
If Ms. Richins would like to use the restroom, that's fine.
We also shouldn't be able to hear what's going on at counsel table. So we'll hear what the court has to say. I've got this sped up until the court goes back to talk about it. They're going to conference about it with the attorneys and the media. Well, that's interesting. So I imagine the court clerk was paying attention. I've got this super sped up. No, I don't ever want to be in trouble with the court. I've got this sped up to get to the court being on the record talking about who's streaming. They should have issued an order for a pooled camera where one camera sends out the feeds and then anyone can stream it. But they said Court TV is streaming, KUTV is streaming, and only one outlet had the order to stream.
All right, thanks, folks. If you wanted to take a moment and use the restroom, Ms. Richins, if you'd like to use the restroom, stretch your legs, this is an opportune time. We're trying to figure this out. Thank you.
So they are definitely taking a break before they come back on the record, but the camera hasn't swooped. The only thing the camera hasn't swooped to yet is the freaking seal. So let's see when the court comes back. There's the seal of the great state of Utah. All right. The attorneys are back at the table. I love being able to do this after it streams so I can zoom to when it matters. Because this is a long hearing. I can't either. If you guys are interested, these hearings are fully up online. So if you want to see if you can hear what is being said, you can. It seems like the media issue got handled during that break, and people are filing back in. They're still filing back in. Judge is not on the bench yet. This is where the other feed I had picked up from KUTV with the witness, who is indeed bearded, is on the stand.
There was some discussion during your testimony elicited by the state.
Now we know exactly how he, everybody's bearded. It's like South Carolina. I got to tell you what, when I was leaving the airport in South Carolina for Dave, all of the law enforcement officers that were inside the airport, all bearded. All of them. It's a whole thing. All right. The court is back in.
All right, Detective. Ms. Lazaro, I apologize for that interruption. Please proceed.
No problem. I'm sure everyone appreciates it. Great, thank you.
I wonder what they've said to the...
A couple more points I want to ask some questions on. There was some discussion during your testimony elicited by the state about CPR given when the night that Eric passed away, correct?
This will not help going forward.
All right. And you've reviewed the case file. Eric a sheet on the floor at the foot of the bed, correct?
Correct.
And that was because when Kouri was on the phone with the 911 dispatcher, she was directed to remove him from the bed to
Hold
the
on.
floor.
I'm going to see if I can gain this up a bit. Give me 1 second. Because somehow this is quieter than it was before the break. And I have everything turned up as much as I can on my side.
Yes.
Okay. And then the 911 dispatcher told her to attempt to conduct CPR, correct?
Correct.
Okay. Do you know if Kouri's certified in CPR?
I do not.
Okay. And for someone in your training experience, if someone doesn't know how to do CPR, it's entirely try, it may not be effective.
Sure.
Yep.
You also talked about what you referred to as bug out bags, correct?
Correct.
I'm not from Utah, but given the amount of time it's somewhat customary for people to prepare for things here, correct?
From my experience, yes.
Yes.
So that would include like food storage, perhaps packing a bag, correct?
Yes.
This is not odd.
And one of those bags was Eric's, correct?
Correct.
Do you recall a label with a date on that bag?
I don't recall a date.
Or
but I
they
do
made a
recall from
statement
photographs
about
seeing
where
it
the
labeled as
camera can be,
Eric's.
because now the camera's on the
And
speaker.
did you said that there was
I think they need to pull it back.
identification documents in there, correct?
Correct.
Are you aware that those are now expired?
No.
You came onto this case or when did you come onto this case?
In April of this year.
Okay. Took over as lead detective?
Yes.
And you, at some point after that, went to Kouri's home, correct?
Correct.
Okay. And introduced yourself and asked her.
I'm speeding this up a little.
Do you remember me? You coached my son, correct?
Correct.
Oh.
And who was the other detective with you?
Sergeant Hoffmeyer.
Okay. And Sergeant Hoffmeyer said, hey, I'm
Look.
your best friend. She coached my son, correct?
That's the judge. That's great.
And presumably, because you are the lead detective, you knew she was represented at that time, correct?
I was not aware of that.
Okay, so you
Huh.
had reviewed the entire case file and did not know she.
I had not reviewed the entire case file at the time that I approached Ms. Richins.
Okay.
I went to the house to introduce myself as the new detective so that she would know that what was going on with the case.
Do you have any questions with the district attorney's office prior to you talking to her?
I do not think so.
Okay. Were you aware of a letter in the file that I had sent to? And
That could be a problem.
specifically, your office addressed the Summit County Sheriff, Mr. Martinez, that I was counsel in the case?
I was not aware of that letter at the time.
So he went to introduce himself as the new detective on the case to the widow, who it seems at the time was also maybe a suspect. But what we're learning is Kouri'd already retained criminal defense attorneys. So she had already retained attorneys before her arrest. Oh, Deborah, we tried that earlier. It was a mess.
With the case,
It
correct?
was awful. It was awful.
After-
We tried.
Yes.
Did you ever ask her if she'd like a lawyer present?
Yes, at one point, her mother came to the house and made a point of should she be talking to us, and I said, if you would like to have your attorney here, I'm fine with that.
Okay, but this was after you'd been talking to her, right?
But so he didn't know she had a lawyer until
Are you-
her mom
what was
showed
the
up?
other detective's name again? I apologize.
Sergeant Hoffmeyer.
Hoffmeyer.
Why are we all talking so quiet?
Are you aware of a conversation
we talk louder?
between Sergeant Hoffmeyer and Kouri where she asked why Detective Woody was removed from the case and he tells her for mishandling?
I
Oh,
recall that.
Okay. Did he ever make mention of that?
On that date at that time, no, I don't believe so.
is that
Was
true?
Detective Woody removed from the case?
She wasn't removed from the case. She could no longer fulfill those duties.
Okay, what is she doing now?
She's in patrol.
Traffic
No patrol.
patrol, as in like a line
Responding
patrol?
to emergency calls, yeah.
Okay, but
She's
she
also
was-
part of the K9 unit.
Not traffic.
So she went from being the lead detective in a murder investigation potentially to
Back
patrol,
to
correct?
patrol.
That happened in our office.
Okay, thank you.
Mr. Bloodworth, anything further?
It's not the only
Yes, Your
law
Honor.
enforcement that happens
start
in,
the
by the way.
process.
Why are they swinging the camera around like this? Autumn, I have no idea. None at all.
Detective, on cross-examination, Ms. Lazaro asked you about
This is redirect.
Ms. She asked you about whether or not the police recovered a glass, a cup, a mug, some kind of container for
pull it
that
out.
drink that evening. You remember that?
Yes.
Were there any glasses or containers near the defendant that evening?
On the evening of the death, is that what you're referring to?
Correct. I guess it's the morning of the 4th when police arrived.
Right. I'm unsure without being there on scene. But from reviewing the body.
Am I right that the only information that indeed Ms. Richins, Kouri Richins, the defendant, gave her husband Eric Richins a drink was the defendant's own words, right?
Yes.
Ms. Lazaro had asked you about gaps in timeframes in cell phones. Based on the carrier records, what have you been able to determine about gaps, particularly from early January until shortly after the defendant's?
We were able to determine from looking at the phone that it appeared that data from several different apps on the phone was missing in that time frame between January and just shortly after Eric Richins' death.
Let me turn now back to CL. The very first time you met with CL, you testified that you kind of laid out kind of the predicament she was in, facing serious charges, but having potentially valuable information regarding a very serious death investigation, right?
Correct.
After that first meeting, how long until you began questioning her about the drug purchases?
4 or 5 days.
So you laid everything out for her on the first meeting and then gave her 4 or 5 days to consider whether she should operate and then interviewed her substantively?
Correct.
Let me talk about that interview. How long after Eric Richins' death are you now interviewing CL?
Over a year.
And
Here in a couple months.
in order to judge, what, if anything, did you show her?
We showed her the contents of her phone that we seized from her home. We showed her applications, Google Maps, Google Earth. We showed her other witnesses' phones or screenshots of those phones.
Huh.
And the other witnesses' phones or screenshots of those, you showed her screenshots of communications between her and that other witness?
Correct.
With the idea that
I'm glad you
the
cleared
might
that
jog her
up.
memory?
Correct.
Is that kind of iterative approach of showing an interviewee information, is that common when you're interviewing somebody a year after the event which you're asking them to recall?
Yes, as from my experience, people have a difficulty recalling information, especially specific dates from that long ago.
I'm that person.
Let me turn now to the April 13th.
That long ago
2023
refers to up and until 2
date
days
you
ago.
Introduced yourself to Ms. Richins, the defendant. What's the first thing the defendant did when you introduced yourself? And about how long did she talk?
We got
3
storms
She
inbound.
did any very excited to talk to you and surprised you taking so long to come talk to her?
Yeah, she made multiple statements that she was glad that investigators were there to talk to her because she felt that she hadn't been in contact with the sheriff's office very frequently before that day.
And
I've got a question. If this is a suspected accidental overdose, why is Kouri Richins wanting to talk to the sheriffs? Like, if something, God forbid, happened to your spouse, your partner, one of your kids, but it was, oh, they had a heart attack. Like, you don't really expect to talk to law enforcement after that. You deal with the coroner and you deal with all of the awful things you have to deal with when someone passes, but you don't deal with law enforcement. So if this was a suspected accidental OD, there's not really anywhere to go with that. No one's going to be charged. Nothing else is going to happen. So why a year after his death is she wanting to talk to law enforcement? Did she know that they were suspecting her at this point? Or did she internalize that and thought they should be suspecting her? I have a lot of questions about that. That's an odd thing to me. Oh, I'm so glad I've been wanting to talk to the sheriff's office. Or is this like Alec Murdaugh, where he's like, I mean, at least in Alec Murdaugh, they knew it was a murder. They didn't know who did it. And he was like, I need information on this homicide. Someone shot and killed my wife and son, right? She's already got lawyers and is like, I wanted to talk to law enforcement. Why? If it's an accidental death, after the funeral, there's nothing else to do. Family man Donnie is telling me to keep reading.
Several times towards the end of the interview when you said your goodbyes, tried to leave, and she continued to talk?
Yes.
It's an
The
odd.
interview after you and Sergeant Hoffmeyer left, did she email Sergeant Hoffmeyer with some follow-up?
Yes, she sent an email with follow-up information. And
Oh,
I'm going to mark if agreeable as Case Exhibit 1 transcript of that April 13th,
Well,
2020.
Y'all, this case is on our docket now, so we're going to be following it.
No.
You gotta show it to Ms. Lazaro first.
Your Honor,
I've got questions.
Your Honor, counsel has the audio of the interview. Actually, the audio.
I don't know what
I believe so. There's a lot there.
I don't know what the coroner ruled.
Your Honor, for purposes of today's hearing,
This is a very good question, actually, Courtney, because I don't know what the coroner, we're at the very beginning of adding this case to the docket. I don't know what the coroner ruled, but I do know that the decedent had 5 times a lethal dose in their system. So it was like a super lethal dose. So they might not have ruled it accidental because of how much was in his system. So that's a very, very good point. Thank you for the reminder. We missed Utah. Yeah, we did. It's lovely.
I think at this point, we weren't sure this was going to come up today. We may need to redact some things from it before it goes public.
Okay.
Yeah, we're not gonna put it in the docket at all, but it can be admitted for States 1 for the purposes of today's detention hearing.
Thank you.
Fine.
Mr. Driscoll, you recall Ms. Lazaro asked you some questions about interviewing somebody with the initials JS. And
There was an autopsy. That's how they know the levels.
approximately April the 20th, 2023, right?
Correct.
We
At
will
that point,
do
How
that.
long had you been active on the investigation?
Less than 2 weeks.
And you told, I think you testified, you told JS something like you thought there were 3 alternatives. One was an accidental death, an accidental overdose, suicide, or homicide. Is that right?
Correct.
At that point in your investigation, were you looking into and investigating all 3 of those alternatives?
Yes, at that time, I had little information about the case.
What did
other
the
than
coroner rule?
A couple of interviews that I had conducted, and I was trying to keep an open mind to all the possibilities.
Thank you. No further questions.
I want to, the swinging camera. I want to know what the coroner ruled.
We're good, Your Honor. Thank you.
Okay, anything further, Ms. Lazaro?
No. Please no.
No.
You can step.
Wonderful. Thank you. Next witness.
The state's,
How's Chris Kotrodimus?
sir, if you'd step in front of Brittany, we'll get you sworn in.
Chris Kotrodimus.
Please raise your right hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth,
God.
to the pains and penalties of perjury?
This is probably the cell phone person.
Sir, could you please and spell your last name?
Sure, it's Chris Kotrodimus. Last name is Kotrodimus.
Thank you. Mr. Kotrodimus, how are you employed at this point in time?
I own a private investigation firm,
What's that called?
M20 Solutions,
How long
So,
have you been the
PI
owner
firm?
of that firm?
about 7 months.
What did you do prior to owning that business?
I was a police officer for over 23 years.
And where did you work as a
Worked with North Carolina, Utah, and took a position with Salt Lake City Police Department where
I know this feed's terrible.
In 2017, I took a position with the Salt Lake County District Attorney's Office on the homicide team there. And
Oh, as a
until my
DA
retirement in
investigator.
December of 2020.
Interesting.
Do you have any specialized training or experience with forensic digital evidence?
I do, yes.
Debbie, this is a
Briefly explain
lot for a bail
Sure.
hearing.
So I have, I've attended several formal courses, one being a Cellbrite Certified Operator course.
Y'all know about
Certified Physical
Cellbrite.
Analyzer course. I've also attended a 40-hour
I have this sped up.
cell phone and mapping course through ZX. After using those skills for several years, I also attended a ZX 40-hour subject matter expert course on the same subject.
These skips
cell
are
phone,
coming
social media
from
mapping,
the
those types of things.
original feed.
My experience related to my testimony and I've worked either directly or indirectly on more than 200 homicides and major crimes, inspected of phone and social and phone downloads.
Thank you. What is your role in the case that brings you to court today?
I was retained by the Summit County Attorney's Office to evaluate digital evidence in this case.
And what evidence have you reviewed?
I reviewed several cell phone downloads or extractions. I've reviewed and analyzed cell records and records, things like that.
Difference between carrier records and call data records are?
Yeah, so a call data record or a cell download is information that is downloaded from a phone onto some type of media.
The Utah feeds have been
And
really
it
tough.
does so into a read, which you're able to analyze the data that's contained within a device, a cell phone extraction or download. A carrier record or detail record is the regular record that you would have. It's the usage of the carrier. So it records the date and times of your calls, your texts, your data usage.
So they're
for a
talking
given
about the
period
cell
of time.
phone
And
dump.
It can include location information, such as like tower data.
Can discrepancies between carrier records and the data that's extracted from a device?
Yes.
What would cause that?
Usually, sometimes it's because it just wasn't captured in the phone download due to a software limitation, but typically where we see it is
Delete,
the deletion
delete,
of
delete,
information on
delete.
that does not match the carrier records that we
Delete,
receive from
delete.
the phone company.
If y'all have learned anything
Forensic
from
extractions
watching
of an iPhone
these
belonging
cases,
to
you know that
defendant
the carrier
was seized
records
April
don't
13th of
lie.
2022.
I did.
Does it contain digital information pertaining to the night of March 3rd and into the morning of March 4th, 2022?
It does.
What does show? Well, let me ask you this. Time that phone is used on March 3rd of 2022.
Activity reported on the defendant's phone is an activity device movement, 22:33 hours or 10:33 p.m. on March 3rd.
When was the next time that that phone was used?
Sorry,
The phone was inactive and then ultimately unlocked
Weather.
at 3:07 a.m. on March 4th, 2022.
Was there anything that happened between those two timeframes?
On that device,
D, there's nothing wrong with deleting old messages unless the carrier shows that those messages might pertain to a crime. Then it becomes sussy. So that.
On that device?
no.
Does the extraction of that phone indicate it moved in that time frame?
It does.
And how are you able to tell that?
Through the download, in this case we use Cellbrite.
Not
for the
yet,
download.
just severe
In the
storms
download,
for me.
It gives an activity, like a connected device activity movement. Usually that's an indicator of another connected device, such as a tablet, watch, or something of that nature. Those two devices will communicate with each other and
Sorry,
report
Marina,
potential
I
movement
do
of the
that.
phone through that application.
Was there anything significant that occurred at 3:22 hours on March 4th?
At 3:22, yes, a 911 call was made.
So between the time that the phone
Chat can answer that.
is used at 3:07 that morning and 3:22, is there any activity that can be seen from the download?
There is.
What is that?
At 3:07, the device is unlocked. At 3:08 a.m., the device reports some type of movement. Either the device itself or a connected device is moving. At 3:12, the phone was unlocked. At 3:16, the phone was unlocked again. At 3:19, the phone was unlocked again, potentially twice. There was movement again at 3:21, and then at 3:22, the 911.
So roughly a time frame of 15 minutes between the first used and the time that a 911 call is placed.
Correct.
Now, the attached device that's recording movement, could that be an Apple Watch?
It could be.
Do you have any way of telling from the extraction you examined what that device was that was recording that movement?
So far in the extraction, I have not been able to. I may at some point, but at this point.
So the phone was active for 15 minutes
And
before
as
the
far as
911 call
movement,
was made.
Is this, what kind of movement is this? Is it significant?
It is significant, I think, for it occurring in a home.
And can you explain what that movement was?
So they're tracking the movement with the phone. Do you remember in the Murdaugh case, the amount of time between Murdaugh showing up at the kennels and then calling 911 was significant? 15 minutes of moving around a house before calling 911 is going to seem substantial. And the prosecution's going to make it substantial. Aurelia pointed out the other part, which is she said she walked in, found him, and called 911. So if there's 15 minutes of her moving around the house, they're going to say, well, of course there wasn't a cup found by the bed because she was cleaning up the house. 15 minutes is a long time.
Correct. So at 3:08, there's movement on the phone, or a device is connected to that phone is moving, and it moves. I don't remember the exact amount of time, but I believe it's several feet. I do know that at
Was it walking?
some point there was two movements right before the 911 call, and they're both significant. One was about 240 feet, it's like 74 meters and change, and the other one was about 130 feet. And this is right before the 911 call.
Okay, thank you. As you were analyzing the forensic data from that extraction, were you able to observe any noticeable patterns of deletion from that phone?
It appears that there is some deletion in that device.
Okay, and can you describe what is being deleted in that phone?
It looks like there's gaps in things like web history, web searches, particularly the call log, when a person leaves a call or a text.
Gaps
there's a recording
in
of the
web
call out of the
history
phone.
and web searches.
And there
Interesting.
are text there's messaging that is included in the carrier report that I would expect to see also logged within the device that are not in the device.
Thank you.
Okay, so you're seeing those in the
That's
carrier
good
records, but
company. I
not
love
on the device
Swoop.
themselves.
Multiple calls and texts to an individual, I would expect to also see the
No,
call log of the device
I don't
itself.
have spinny
And
weather.
In a
We're
lot
good.
of instances, particularly there's a lot of that is missing.
And from the carrier records, are you able to tell who those calls were going to?
Yes.
Who was that?
There are several people, but as it relates, one that stood out was that has been mentioned as CL.
In those carrier records, were there logs of calls made in January of 2022?
I don't recall January.
Did you analyze a forensic extraction of a second iPhone belonging to the defendant that was seized in May of 2023?
Yes.
When did activity?
The activity on that phone started shortly after her original phone was seized in April of 2022.
Okay, so her phone was seized back in April
Were you able
2022,
to
and then she got a new
observe,
phone.
Internet searches on that phone.
Yes,
And did you a PowerPoint of some of those searches?
I did.
Oh, there's a
And just for the
PowerPoint?
court and counsel's reference, this is docket item 141. Were you able to tell when those searches were made?
Spoilers!
How did you do that?
There is a date and time stamp of the history, the web history. So,
Ooh,
for instance, if you visit a website and you click through it using your device, it will report what date and time that it did that connected to that website.
it does do that.
On April 18th of 2022, internet site of an article entitled "What Happens to Deleted Messages." On May 10th of 2022, did that phone access a site for an article entitled "How Do Police and Forensic Analysts Recover Deleted Data from Phones"?
Well, that's curious.
Did that phone ever, was a query placed in that phone, quote, "Can cops, period, uncover deleted, period, messages, iPhone," close quote?
Yes.
Did that phone search, quote, "How to, period, permanently delete information from an iPhone remotely," close quote?
Yes.
You cannot.
Did that phone search, quote, "Luxury for the rich in America"?
It did.
Did that phone search, quote, "If someone is poisoned, what does it go down on the death certificate as," close quote?
Yes.
Were you able to tell when those things were searched?
The search themselves, there was no date and time reported for the individual search. However, I found corresponding websites to those searches that did have the web history.
And was there a certain time frame that these searches were made? Can you describe what that was?
It's typically between, well, shortly after her original phone was seized. So from middle of April of 2022 through, memory serves me right, about August of 2022, off and on.
Thank you. Now, you mentioned your
He died in March. Her phone was seized in April, and she was then searching how to delete things off an iPhone remotely while the phone is in police custody. This is why I don't pre-watch these things, because I want to watch them with you, but self-snitching is an interesting thing.
training with cell phone mapping using cell tower data.
Yes.
Have you, in your review of the evidence in this case,
I have.
Can you explain just briefly cell phone mapping?
Yeah, the luxury prison is
using
a
cell
whole
phone-
thing.
Cell tower data.
Sure. I'm sorry, I looked that way. I'm used to talking to a jury. so
He
so
said,
it's,
I'm used to talking to a jury.
mapping is accomplished by taking call detail records that contain tower location in them and putting them into a piece of software that will visually show you a location on a map of which tower that device was accessing when it made or received a call.
Yeah, somebody should have told her that if you're getting luxury prisons, you need to steal from rich people. You need to be rich, and then you need to steal from other rich people. And then maybe, I want to see if Jen Shaw prison was in any of her searches, because Utah. But you have to commit federal white-collar crimes. Murder's not going to get it there. Yes, I know that is full Bruce Rivers. Which state has the luxury prison? Federal white-collar crimes. Oh, the thunder is rolling out
Lines of
here.
data and creates a map out of it.
And is that?
Ooh,
plotted
I
on
love
the
this
program
prosecutor's pen.
And
These I like.
Are you
a
able to
lot.
tell directionality from when a phone connects to a tower? Is there any directionality to that? Approximately where that phone is,
Yes.
is transmitting from?
Yes. Yeah.
There's
So the cell phone, the companies
pie
report which
slices.
tower the device is utilizing.
But there's
which
pies.
is an estimated range to that, which is a bit ambiguous. However, it will tell us at least what side of the tower that the device was located when it made or
This
received
feed is rough, but
How
all
many
the feeds
sectors
are
there
going to be
on each
rough.
cell tower?
3.
Okay. And so if a phone is connecting to a tower through a certain sector, tell that it's at some place where that's, for lack of a better word, broadcasting or collecting
Yeah,
signals.
so we can determine the orientation of the device to certain locations.
I see.
Yeah,
Did you map data from CL's phone extraction?
I did.
This
Were you
is
able to track that phone's movements
fascinating.
on February 11th? You do.
Yes.
At any time, was it at or near a Maverick gas station in Draper, Utah?
It is.
And are you aware of that location?
See, when they talk to the confidential or when they talk to the informant CL about the specifics of when they're then able to take the phone data and match them up and be like, y'all were at the gas station at the same time, though. And those are the things that start to corroborate what CL has said when CL is like, we went to the gas station at this time. Well, your phones are going to tell if you were both there together.
This investigation.
I am. This is the location that CL had indicated to detectives that she bought drugs on behalf of the defendant.
Do you recall approximately what time of day that was it was there?
She shows up on that tower near that Maverick at about 6:49 p.m. and remains there until about 8 p.m. 2022.
Does that phone make any calls or well at that location?
It did.
And to anyone notable to this investigation?
Yes, 2 people.
Who was that?
One other acquaintance in which she had purchased the drugs from, and CL was also texting with the defendant.
While she was at a gas station in Draper, narcotics.
Correct.
On that day, did the phone go to a location in Heber City?
It did.
Was the mapping that you did CL's phone consistent with what CL gave to law enforcement regarding that first drug purchase?
Yes.
Were you able to track
Well-
CL's phone movements on March 9th of 2022
Yes.
There's that.
in Francis, Utah on that day?
It was.
They were at or near the same Maverick in. Were there any communications from the phone at that time while it was at the Maverick?
Yes.
Did it communicate belonging to a person relevant to this investigation?
It did.
Who was that?
At the Maverick, it communicated with, I guess, corroborating witnesses to the drug purchase on the 9th. When the device was utilizing it in Francis, it was about mid-9th, and CL's phone was in communication with the defendant's phone.
So the phones are in communication, and it's also showing where the phones
Did the phone
are.
go to a location in Midway, Utah on
Midway.
or about that day?
Yes.
Are the movements that you for CL's
So the defense did all that great cross-examination about the Midway house and whether drugs were really getting left at the Midway house, and everybody's phones are just there? Oh, okay.
cell phone on March 9th of 2022 consistent with the information she gave to law enforcement in this investigation? Finally, I want to speak with you briefly about Mr. Eric Richins' phone. Did you analyze a forensic extraction?
I did.
When was the last use recorded from Eric's phone?
From memory, I believe it was p.m. on March 3rd, 2022.
And are the times that are on the extract populated in the Celebrate download, are those, what time zone are those living in?
Typically, the
Okay,
extraction is
okay.
0.
And so do you have to, so can you just briefly explain what UTC 0 is?
Right, so UTC 0 is Greenwich Mean Time. It's an effort by utilize investigations to try and keep everybody on the same time zone. Utah is in -7 daylight time, and we are in -6 in daylight savings time. So in this case, from November of 2022 to about March 13th, I'm sorry, November of 2021, March 13th, 2022, in Utah.
Okay. So if those times are given on that download as UTC -5, that would be
Correct. It would be
Weather
2 hours
alerts.
ahead of local.
Just
to
weather
adjust For
alerts.
Mountain Standard Time, you would have to go back 2 hours.
You'd have to subtract 2 hours. Okay.
And that's what gave you, can you repeat that the last time that Eric's phone was used on March 3rd?
I believe it was 9:58 p.m. on March 3rd.
Okay, thank you. I just have one.
He died in the evening or the
Thank you, Mr. Kotrodimus.
late night March 3rd to March 4th is when he died. This will be cross-examination. Should be pretty quick, but we'll see.
You testified there are essentially 2 explanations for why things might be missing. One in a download. One is that it's not captured in
The whole thing just froze. That's not me.
Correct.
Okay. Now, with regard to movement, that could be any device that is attached to the phone through an app, correct?
It could be, yes.
Okay. And so you can't say, looking at what you analyzed, exactly what device that was, correct?
So far, no.
Okay. And you can't tell where that device was in terms of location, correct?
Correct.
So it's possible that that could have been a device attached from some other location, but the phone's recording it, correct? But it's possible, if it's connected to an app.
It depends.
Okay,
So it would be impossible outside a certain range.
okay. And there's a number of different ways to, or I am not an expert in this, so there's programs or extractions that can be done on phones, correct? Or different. Did you perform an independent extraction on this phone?
I did not.
Okay, or on any of the phones you've talked about today?
No.
The extractions came from law enforcement. Okay.
Did you analyze any data prior to January of 2022 on either CL's phone or either phone, or I guess the first phone belonging to Ms. Richins?
I don't believe I did.
Okay, were you asked at a
Not necessarily.
Their feed is freezing. I'm going to switch
Range of interest.
feeds.
Okay. And so
When
you
they
didn't
switch,
cross-reference
I'm gonna switch
any
feeds.
communication or
When we switch.
communication between CL and Kouri prior to January of 2022, correct?
Correct.
So it could be that they communicated all the time, you wouldn't have known.
Yes.
So this is just a connection between the two.
So when we switch witnesses, I'm going to switch feeds and see how it
Were you
goes.
made aware of when warrant was, or when the first phone was seized?
Yes.
Okay. Copy of the search?
No.
Were you made aware that the warrant included evidence of homicide that they were looking at?
No.
And in that first phone, prior to Eric passing away, were you able to review any search of the web browser,
Whose device?
first device? Mr.
Yes. Yes.
Okay. And did
I'm
was
very
related to phone call
curious.
on that?
Not that I found it. There were available to
And
look at.
okay, no searches related to prisons either?
No, not in that time frame.
No searches related to deleting messages?
No.
So no searches
And
before
So
he
all the searches
passed.
came from the second phone, correct?
The web searches mentioned? Yes.
Okay.
Yes.
And phone that was issued for the first phone, correct?
That was, yes.
That's the
So
phone
that
you got
was-
as a replacement, right?
Yes.
Okay.
This is quite an extensive bail
Um,
hearing. The
just wanna-
only other bail hearing that was quite this extensive was Josh Duggar's. And that was this expensive. That was this extensive.
Return to this mapping that you discussed. Did you look at the mapping on the second phone of Ms. Richins?
I did not.
So, to compare Ms. Richins' phone to CL's location at any point, correct?
They did.
Okay.
Very
But you couldn't
normal
do it? Or didn't
for
do
the
it?
defendant to be
Records,
handcuffed.
The mapping location for those call detail records through Verizon are no longer available
On the second phone?
on either phone.
Okay, so you were able to get him off of CL's phone, but because of Verizon, you weren't able to get Ms. Richins' phone?
Correct.
And on that March 9th date, you discussed midday, Maverick, time, was she at that Maverick?
This is
It was
after
about
Eric Richins dies.
3 p.m.
After,
She was
To
she was
Francis.
in Francis around midday. She was at the Maverick at about 2:33 p.m.
okay. Did she go back to Francis?
Feel better,
She went to Heber.
And
Iris?
she lives in here? I don't think I have any other.
We have one IKEA in our state.
Mr. Hill, anything further?
It's just way on the other side. My state is long. It's easier to go south.
Yes, Your Honor, State Public Carrington.
All right. I'm going to switch feeds to see if we can avoid the skipping. The other feed was not super clean at the beginning. I'm optimistic. We now know there are multiple cameras in the courtroom. So let's hope this feed doesn't skip as much as that feed. Let me bump this up to our 1.25 or 1.5 speed. Let me make sure that we've got closed captioning on. And let's try the other feed. All right. Fingers crossed, friends.
Ms. Cassell.
Yes, Your Honor, State Public Carrington.
Brooke Carrington is who is being called. I can't gain this up much more.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the
Oh,
truth,
and
the
this
whole truth,
one's
and
in
nothing but the truth,
mono.
subject to the pains and penalties of perjury?
Okay. Sorry for the audio in mono instead of stereo.
Morning. Could you spell your, I'm sorry, could you state your name and spell your last name, please?
Brooke Carrington, Karrington.
How are you employed?
I am a principal managing partner at Carrington Financial Forensics.
This doesn't seem to be skipping as much already. So financial forensics. Tell me more.
Is this a company that you started?
Yes, it is.
And when did you do that?
Officially in, I think 2012, when I registered that business, but I'd been doing this for about 35 years.
What's the nature of your business?
I look at, most of the casework I get is forensic accounting, and most of the casework is cases where there are allegations of fraud or missing or misappropriated funds, tracing of bank transactions, and casework like that.
And how long have you been doing that?
35 years next month.
Do you have an undergraduate degree?
I do.
What is it in?
It's in English.
And what about a graduate degree?
I have an MBA.
Wait, ma'am,
Do you have any certifications or other
Ma'am?
degrees?
Yes, I
How
have.
did you
I'm a certified,
go from an English major
fraud
to a
examiner.
forensic
I also
accountant?
am certified in anti-money laundering transactions. I am also working towards certification in blockchain and cryptocurrency.
Oh,
So this is probably going to be a lot. But in your 35 years of forensic accounting, how many cases have you worked on?
A couple of years ago, I had to quantify that, and at that time, it was about 4,600. So
So probably more
Wow.
now.
more now.
Okay.
that's a lot of
Have you
cases.
provided testimony in financial crimes cases?
Yes, I have.
How often?
A handful of times per year, I would say.
Okay. How did you first get involved in this case?
I was originally contacted by the investigator for the estate of Eric Richins,
And who's that?
Todd Gabler.
Okay. And why did he contact you, or what was his reason for contacting you?
Mr. Gabler and I have been acquaintances and colleagues for 30 years, and he expressed to me that I have a skill set that he knows nothing about. So
Okay. And who hired you?
the estate hired me initially.
Okay. And at some point, were you retained by the Summit County Attorney's Office?
Yes.
When was that?
I believe it was May 31st of this year, just a couple weeks ago.
Okay. So as part of your being hired by the estate and being retained by the Summit County Attorney's Office, have you reviewed any documents
Why did Eric Richins' estate need a forensic accountant? What were they concerned about before this arrest? This guy is being menacing. I have a lot of questions.
that are relevant in this case?
Yes.
What have you reviewed?
I've reviewed bank account statements, tax return documents, real property records, specifically trust deeds and warranty deeds, reconveyances. I've also reviewed insurance policy documents, tax information.
Okay. Specifically with respect to the defendant, were you able to determine whether or not she owns any businesses?
Yes.
What business does she own?
She owns several businesses, and the most relevant one to this case, I believe, is Kouri Richins Realty, LLC.
Okay. What kind of business is that?
It's in the business, in the realty business, real estate business, and I understand she flips homes, but she also acts as a realtor representing people who are purchasing homes.
Okay. And when did she start this business?
It was registered in Utah in April 2019.
All right. Were you able to find information
These are the
regarding
defendant's businesses?
defendants buying and selling of homes?
Yes.
And how did you find that information out?
Those documents are typically recorded, and they are public documents, and they're typically recorded at counties, recorder's offices. There's also information along that line at the assessor offices, and each state has a little bit different process of doing them. Most of them do it the same way that Utah does, which is through the county recorder.
Okay. I'm going to show you.
I am
Let me
sure
approach it.
Ryan is probably live. There's other
What's been marked?
spinny weather. I just have tornado, or not tornado.
This is a schedule that I prepared. I use the term schedule to talk about my work product
Nashville Severe
and
Weather's live.
the analysis and how I depict it. So this is a chronology of the real properties that I was able to identify attached to either Kouri, Ms. Richins personally, or through her company.
Okay.
Oh,
Does it
the
show a
house.
timeline of acquisitions that she has made?
Okay,
Yes,
so they're gonna talk about the
I should
other
underscore
property
this is a
we've heard
timeline that they were acquired.
Okay.
So just this is the front end of her ownership.
Okay. And in 2019, and this is when her business was started, is that correct?
That's correct.
How many homes so far have you been able to tell whether or not were acquired by the defendant?
In 2019?
Yes.
In 2019, I have two properties listed. One of them is the home that they were living in, and that's when the HELOC was taken out.
my
And the
equity
other
line
one is a
of
different property, so I've listed two there.
And you've listed an amount of trust deeds for 2019, is that right?
That's correct.
Can you explain what those are?
Trust deeds are deeds that are recorded at the county recorder's office, and they are memorializing or documenting an obligation or an encumbrance on a property. So this would represent that there's a loan for a certain amount, and that's expressed and documented in a trust deed.
Okay. And how much money, I guess?
Sorry for the jump scare,
or
y'all.
trust deeds, or what was the amount of trust deeds in 2019?
Those two trust deeds total $471,210.48.
And you've done that for each year, 2020 and 2021 as well, right?
That's correct.
And what was the amount in 2020 of trust deeds?
2020 was $2,069,280.
On how many properties?
On 5.
Okay. And 2021, what was the amount of trust deeds and that the defendant acquired?
Trust deeds.
The amount there is $6,260,458.
On how many properties?
On 13.
Do you find this significant?
Yes.
And why?
That's a lot to
On a
flow.
positive note, it depicts that the business was growing and she was actively acquiring properties. I think it's noteworthy and it's an indication that things
I
were
know it's
growing
thundering.
quite significantly, and sometimes that is problematic.
And why is it problematic?
But it's kind of a basic thing like in business school where growth too fast, too strong, too robustly is challenging for business.
Yeah, it can.
Okay. Were you able to determine at the end of 2021 how much the defendant was obligated on those debts, those $6 million debts? And actually explain to me the difference. What does obligated on a debt mean?
That's a lot.
That's a very important question and very important point to understand here. I don't have access at this point to the documents that tell me the terms of these loans. So I don't know what the interest rate is of these loans. I don't know the terms that she's agreed to for these loans. I don't know what payment is required on these loans. What I do know is these are what we colloquially call hard money lenders. And I do know on some of these what these lenders do require, and it's in the neighborhood of 12 to 15%. These are not conventional loans where there's a 30-year payment amortization. These are typically short-term loans, and people in the house flipping business, the fix and flip business, typically
Fix and flip.
are turning those
I like
over
it.
a little more quickly, so they don't need a 30-year loan. They need a shorter-term loan. So I understand what she's obligated on, but I do not know what the balance is at the end of a particular time period.
I see. You need more information to make that determination. Is that right?
That's correct, and that would be the loan documents themselves, the promissory notes, and the ledgers from the lenders to show what payments were or were not made and when were they made, how the interest was calculated and accrued, what other fees. Typically, these lenders have significant loan origination fees, and if payments are late, then the interest rate is higher on the late payment. There are perhaps default fees, things like that.
Okay. So do you have a rough estimate on what she was obligated to at the end of 2021?
Yes.
And what's that?
At the end of 2021,
Yes.
was a little over $4 million.
Okay. And you don't know if that's you don't know what she paid back, but you know that was what at that point she was obligated.
That's what she was obligated on these properties that she still owned at that time. And this is...
So money's going to come up as a
believe I've
motive.
done
At the end of 2021, she's extended $4 million in loans for properties she's flipping. Okay.
a pretty good job looking for properties, but there may be others that I don't know about.
Okay.
So money
Were
is
you
an issue.
able to look at
Or money
bank
might
accounts
be
that
an
belong
issue here.
to the defendant?
Yes.
And what is servicing a debt? What does that mean?
That would be a term that would explain that there is a debt outstanding, and servicing a debt would be the payments on that debt.
By the way, with cases where it's like, well, there's murder and there's financial stuff like Murdaugh, it happens. And we're hearing some of that here. So I don't know. I'm real interested to see where this goes with how extended she is on the homes.
So if I have a credit card and I have a monthly payment, or I have a balance due, my payment toward that credit card is called servicing my debt.
Okay. And were you able to determine how much debt the defendant was servicing in December of 2021, for instance?
Yes.
How much was that?
The debt payments?
Yes.
The debt payments were about $252,000 in that month.
$252,000
The debt payments that she made in December of 2021, there were 94 payments, and those 94 payments totaled $252,000.
Is there anything that you found significant about those debt payments?
Yes.
What was that?
They were not to 94 individual entities. Some of them were weekly payments. For example, I know that she has an outstanding debt during that time of $5,438 that was required to be paid weekly on a debt. She has a $600 payment that is made daily for a period of time during December. And
Daily?
the payees on most of those debts, the large majority of those debts are hard money lenders. Some of them are credit cards.
And this was in a particular account you looked at?
That's
correct?
just in one account, yes.
Do you remember what account that was?
That's the account 6577.
Okay. Were you able to determine if she was current on her debt payments that were coming out of 6577?
There's other accounts?
Did I say that number correct? Yes.
Yes, you did. I know of one account that she has that had sued her, and they filed suit in New York in December 9th of 2021.
Okay. But, to ask you about that, I'll ask you about that one in a minute. But were you able to look at the bank account and determine whether or not she was current on her payments or whether her payments were going through correctly?
I can't tell you if she was current on her payments. I can say about those payments that several of them did not clear the bank. And
Why was that?
She was in the negative in that account. From a good part of that month, she was $22,000 in the hole for a good part of that month.
So you noticed that, at least for that account in that month, that that some of the payments to the hard money lenders were not going
some
through?
of these
That's
payments
correct.
are bouncing.
Did you notice any
She's over
charges for overdraft fees or
$22,000
anything
in
like that?
debt.
Yes.
Okay, well, what did you notice about that?
They were $25 each, and sorry, I don't recall what the cumulative.
The overdraft fees are $25 each. Remember how low the overdraft fees were in Murdaugh? Kouri Richins did not have the Murdaugh privilege with her banking, it seems.
Number is for that, but there were dozens.
And this is one account.
Now I want to ask you about this. You said that there
sounds
was
like many.
a lawsuit that you were familiar with out of New York?
Yes.
Can you explain what you found out about that?
So in that case, they did file the agreement. And so from that, it's apparent that Ms. Richins used receivables of $87,000. And receivables are her potential revenue. It's work that she's performed or earned, and she's expecting to be paid this money to her company as revenues. So that's $87,000 that's stated in the case, in the document that they filed with it. And that agreement also says that she's borrowing $60,000 against that $87,000 at 15%. And that document also spells out the terms of the agreement that she's to make weekly payments of $5,438 until that debt is paid.
Weekly payments of $5,400 until the debt is paid. That's substantial.
And do you know why this lawsuit was brought? Or what the documents indicate about why the lawsuit was brought?
According to the complaint, which is the other side's version of what happened, that she made payments of about $21,000. So that would be a little shy of 4 payments. And then after that, she defaulted.
Okay. And when was that lawsuit filed?
December 9th, 2021.
So we talked a little bit about the
$5,000
bank
a
accounts, at least
week.
do you know where the Kouri Richins Realty bank account, what the bank is?
Were they banked?
Were they banked?
Yes.
What is that?
America First Credit Union.
Okay. And were there any other America First Credit Union accounts that you were able to look at?
Yes.
And when were you able to look at those?
Over this past weekend.
Okay. How many accounts did you get access to?
I can gain me up a
Probably about
little.
11 or
Sorry,
12.
Okay. Were some significant?
Yes,
Were some not?
that's correct.
Okay. I'm going to ask you specifically about
So for
each of these.
for everyone asking, how is this relevant? They're arguing there's not enough to tie her to these crimes. So this is showing the judge there's enough to hold her without bail. That's what some of this is.
In order, or not each of them, but a couple of them in order. There's the 6577, is that right?
That's correct.
What was, and that was the Kouri Richins Realty, right?
That's primarily,
12
that
is
is
a
the name
lot.
of the account, and that's, as far as I can tell, that's primarily where the transactions were housed.
So in
And you said
real
primarily
estate,
the hard money lend.
sometimes in real estate, especially with flipping, you'll have one account per property, but it doesn't sound like that's what's going on here.
Lending payments.
Primarily there.
Okay. And that one ended up in about negative 2,200 at the end of 2021.
22,000.
22,000. That's, I'm sorry, you're right, 22,000.
22,000 is more than 22.
Did you look at 2204?
Yes.
What primarily was that?
That's the joint account, so we would call that a personal account. It's a joint account. It's held jointly with Eric and Kouri Richins.
Anything stand out in that account to you?
Yes.
What was that?
Well, it's important to me to look at kind of a runway of the account leading up to a significant time period, because it's important to understand the nature of an account. And so I've gone back to 2020, long before the review period that's relevant
appreciate that.
specifically in this case, or that is people are concerned about in this case, to understand what the nature is and what's the character of that account, how is it used, and what's typical for a particular account holder. And that's going to be different for every person and every business. And so I looked at this account, and typically it is the account that is used to pay credit cards and kids' expenses and family expenses and things like that.
Okay. Anything else stand out as you review the account?
Yes, as we get closer to the time period that's relevant here, which is like the months leading up to Eric's death, I would term that, and then what happened after. There are transfers between accounts and amongst accounts. I can see, Eric's payroll coming into that account. I can see there are some deposits from, or transfers, I guess I should say, from Kouri Richins Realty, payments going back to Kouri Richins Realty. There's a marked increase in the number of transactions that occur in that account and all of the accounts.
Okay. So you actually see an increase of money moving around in that account, say, late 2021 and up until Eric's death?
That's correct, yes.
Why is that significant? Why do you find that significant?
Well, I'm looking for what's typical or what makes sense. And so I'm looking at, what's happening in the business account, and does that influence what happens in the personal account, along with what is happening in the acquisition of properties and how those move together. And so there's this kind of noteworthy crescendo that happens in the months leading up to Eric's death. There are indicators of an increase of chaos and loss of control and larger amounts of money moving all around the accounts.
Chaos is not a good way to describe your banking.
Or a negative way?
It feels haphazard. There's not a pattern. There's not a practice that there had been a little bit earlier in my review. And there are transactions that don't clear when there's, money is moving around just to cover transactions.
Okay, and I'm going to ask you about those transactions that don't clear in a minute. But I'm going to go to ask you about account 5244. Are you familiar with that account?
Yes.
What is that account?
That is also a personal account. That was opened in 2013, and the header on the bank statement has Kouri's name, but the signature card, and until I looked at the signature card, I thought that was just Kouri's account, but the signature card does have Eric and Kouri as joint holders.
And what is that, what do you believe that's primarily focused when you review that?
I thought that was a business account.
Okay, is that what you continue to think?
It's technically a personal account.
Okay.
According to America First, that's a personal account, but it is used as a business
And
account.
why do you say that?
Because of the transactions that are contained within the account.
What kind of transactions are they?
There are some payments for the loans on these properties. There are expenses that I would think would be typical of a business rather than personal. But there are some personal expenses there. I'm not saying that to be prejudicial or negative or anything. It is what it is.
Okay. Are there any credit card payments coming out of that account?
Yes.
How many credit card? What's the amount of credit card payments coming out of that account?
I didn't quantify that.
Okay. So at the end of did you
I love
review
an
the
accountant
bank
testifying.
statement for that account for
They're often so
5244
clear about-
for the end of 2021?
They didn't.
Yes.
It's just
What was the status
it is
of
what
the
it is.
account then?
That was also in the negative. It was negative about $1,100, $1,700, something like that.
Was there a line of credit?
Yes, there was.
How much was the line of credit?
$3,200,
And what was the status of the line of credit?
and that was exceeded.
Okay.
That was tapped out.
Okay.
So they are painting the picture of the
So you
financial
mentioned
strain
some, I guess,
that this defendant was under.
transactions that did not clear. Is that how you put that?
That I did. Yes.
Okay. And where did those, in what accounts were there transactions that did not clear? Do you remember?
I know the 6577 account, 5244 account. The 5244 is the one we've just been talking about. The 2204 account is the personal account, the joint personal account, and that also had a lot of money moving in and out, and did have some transactions that did not clear.
So I'm going to direct your attention to a transaction that occurred on October 13th of 2021. Do you remember looking at that? Where there was a check coming in from a credit union?
October 23rd of 2021?
13th.
October, for what amount?
For $4,000.
Yes.
Okay. Tell me, and that was into 6577. Is that right?
I believe so. Are we talking about 2021?
Yes.
Okay.
And it was from Penn Fed. Do you remember that?
Yes.
Okay. Can you tell me about that? What you recall about that transaction?
Penn Fed Credit Union is a credit union where Kouri Richins has accounts and Eric does not, and that becomes a significant issue later. But that check was deposited into the account, and then it was returned unpaid.
And do you recall if there were any transactions made out of the account between the time the check was deposited and it came back unpaid?
I recall that there were transactions, yes.
Okay. And there was another couple of checks were deposited on November 12th of 2021 that did not clear. Do you remember those?
I remember that there were checks, yes.
Okay. And after those checks were deposited, do you remember if there were any payments made out of the account before it came back unpaid? Sorry.
The same is true, yes.
And do you remember who those were transferred to, or where those were transferred?
I don't recall specifically, no.
Okay. But there was money transferred out between the time the check was deposited that didn't clear and the time.
That's correct.
Okay. And then in December 23rd of 2021, do you recall any checks that were deposited, a check for $10,000 from the Navy Federal Credit Union?
Yes.
And what happened to that check?
That did not clear as well.
Okay. And checks take a while not to clear, right? Is that right? So a check is deposited, it's credited to
Yes,
your
it
account,
takes
but there's some
time not to
time in
clear.
between the credit and it coming back not cleared. Is that right?
Yes, that's right. But it depends on the relationships between those financial institutions. Sometimes they'll clear overnight, sometimes they'll take a few days.
Now, these seem to take about 4 or 5 days. Would that be
That's
about right?
correct. I remember that there were two that did not clear, and they both came from Ms. Richins' Navy Federal Credit Union account.
So these were checks written by the defendant and on the Navy Federal Credit Union account and deposited into her America First Credit.
That's correct.
It didn't. Was there money between the time that the check was deposited and the
So
time
money is
it came
moving
back
between the
as
two
unpaid?
accounts
Were there any transactions out of
and not
that
going well.
6577 account?
Yes, there were.
And what were they?
I don't recall.
Okay. But there was a time when the money was moved out of those accounts.
That's correct.
Okay. In 6577, do you recall, I know you testified that it was overdrawn at the end of the year. Do you recall if it was overdrawn prior to Eric's death?
I do. I don't remember the amount, but it was, again,
Overdrawn?
yes.
Okay. Do you, and again, I want to ask you about, go back to 5244. And I think,
we can move on from the accounts.
okay.
The judge is like, I get it.
Let me ask you about the life insurance policies. Are you familiar?
Thank you, Your Honor. He's like, this is not a financial crime. This, I understand. You've painted the picture. Let's continue. Life
With
insurance.
life insurance policies that
Yes.
on Eric's
Life
life?
insurance is
Yes.
very
How
interesting.
many life insurance policies were there on Eric's life at the time of his death?
I believe there were 6.
Okay.
6? Ma'am. 6? Oh, you know, the next time I do my reading for Policy Genius, we're going to talk about this.
What were they? Can you explain what the life insurance policies were?
Yes. The first was through Minnesota Life for $347,000, and that was what is typically called a home mortgage policy, in which if the insured passes away, the home's paid off, and they write it at the amount of what the loan balance was at the time the policy is taken out. And so whatever the loan is at the time of death, I believe that loan is like 72%. They'll pay 72% of the outstanding loan, and so that one was paid.
So they'll pay
Okay,
72% of your
And
mortgage
then
if somebody dies.
there's a life insurance policy that Eric and his business partner had on each other, basically, and that's in coordination with a buy-sell agreement on their business. And so if one of them passes away, the other would be the beneficiary of that life insurance policy.
So let me just ask you about that instead of going through one at a time. How, besides the life insurance policy that was on Eric's business, what was the amount of money that Eric's life was insured for at the time of his death?
About $1.2 million, aside from the business buy-sell policy.
And are you familiar with any attempt to change the beneficiary of the business policy?
I'm aware that that is the report, yes.
And what was the
Bing, bing.
report?
That on New Year's Day of 2022, that in New York Life's online portal, someone had logged in and had changed the beneficiaries on that policy
To
Kouri Richins.
okay. And that was changed back, as far as you know, had been changed back at the time of Eric's death.
That's my understanding, yes.
Okay.
So it was changed to Kouri,
You know
then
how much
changed
money,
back to the
Senate got in
sister.
insurance payouts?
$1.3 million, a little bit more than that, $1.3 million in June of 2022.
Okay. Can I just have a minute, Ryan? Of course.
So 1.3 million was paid out from the life insurance in June 2022 or 2021. Sorry, no, 2022. What year are we in? Last year, June last year, a year ago. He died in March last year. In June last year,
I have a couple more questions, Your Honor.
it was 1.3 million paid out.
The PenFed accounts at any time?
Yes.
Do you recall if there was any money in those accounts?
For most of the time, I reviewed a little bit over a year. I believe most of the time it had $5 in it.
Okay. Right. I have no further questions, Your Honor.
All right.
Really quick because
Well, hey, yeah, just take what it takes.
Okay.
They're on
Cross-examination.
notice that I'm otherwise engaged.
Okay, I needed that. Ms. Carrington, a couple of questions. I want to talk about, pursuant to your testimony, you've been doing this for a long time.
Yes.
And you look at investment type businesses as well as personal finances, correct? As
That's
the
correct.
course of your review of things. And you said that
The judge was
Kouri
writing.
Richins Realty
The
was
judge was
essentially
writing
flipping
quickly,
homes.
but also I've got this sped up.
Is it business?
That's my understanding from what's publicly available. Yeah.
And
The job of an expert witness is to know their report. We saw this play out in Depp Heard, where one of the expert witnesses were like, "But Your Honor, I don't want this to be a memory test." It is a memory test. Oh no. I paused and now it's giving me the circle of death. Don't do that. We're doing so well.
in your experience, that type of a business model is essentially investment properties that you don't own very long and then you resell, correct?
Yes.
So within the framework of that, it would not be uncommon or uncharacteristic to have these hard money lenders as a part of that type of business model, correct?
Yes, and that, I did say that earlier, that that's typical.
Right,
Yes.
we wouldn't go get conventional home loans for a home we're going to own for, 6 months, we hope, correct?
You could. That would be a lot lower interest rate. Even though it had a longer repayment period, someone could get a conventional loan to do that.
It would be hard to continue to get conventional loans, I would assume, when you're buying multiple properties, correct?
I don't know the answer to that. What I will say is it's very typical for someone in this industry that Ms. Richins is in to get hard money lenders.
So what she was doing was typical for the industry?
I would say yes.
Okay.
That was the
And
question.
you created this
That was the answer.
schedule of homes. Did you also look at when those homes sold?
Yes, I did.
Okay. And did you correlate those payments?
Correlate.
Like, were you able to see what the homes sold for?
I have been able to see many of them what they sold for.
Okay. So, and then if you look at those, she only still owns a handful of those, correct? 4, maybe 5.
I'm sorry, what?
She only
period?
still currently owns just a small handful of those homes, correct?
I think she still owns about 6 or 8.
So she owns the ones on Canyons Resort Drive that are rental properties.
That's
Okay. And she owns the Saratoga Springs house.
Yes.
Okay. And
She still owns the condo in B Street in Salt Lake City.
correct in the Heber City.
Yes, she does. It's under joint tenancy, and K. Richins Realty is still on the title on that.
And were you able to see on any of these hard money loans if she partnered with anyone on them? It's not just a hard money loan, but if there were any partnership.
The trust deeds did not indicate a partnership.
Okay. So you wouldn't know if there was some other partnership that existed on these.
Yes, that would be reflected in the trust deed, and I did not see any partnership on any of them.
So you don't know if there's a partnership or not. Well, actually, it would be reflected. We love a well actually.
Were you able to see what the balance in the 2204?
I want them to zoom back out. I want to see the judge's
as
face.
part of your review of
The judge's face is very
At what
telling.
time period?
at any time period. Did you look at the 2204
I did,
account
yes,
as well?
yes.
Okay. And although there were fluctuations in her business account, that account always had sufficient funds in it, correct?
That's not correct.
Okay. There was a period of time where it did not.
There are periods of time, yes.
Very, very specific. There are periods of time where the accounts did not have sufficient funds.
And you also said that Eric was on this 5244 account that was being used for essentially business type stuff. And that was Kouri's business, not Eric's. Is that correct?
You're asking me a couple of things.
Okay, sorry, I'll slow down.
He's
That's
on,
okay,
no, it's
yeah.
fine, it's fine. He's on the signature card. So when an account is opened, he signed as an authorized signer, she signed as an authorized signer.
Okay.
As
So
I-
he would have, as an authorized signer, he would have access if he wanted to go review what that account was doing, correct?
Not necessarily.
Okay.
That all depends on how it's set up with the online access. Just because someone's an authorized signer doesn't mean that they can come in and walk into the bank and get any information they want.
Were you able to tell in this case?
Well, as I said, the bank statement does not say Eric and Kouri Richins, it says Kouri Richins. And looking at the transactions in the account before I looked at the signature card, it looked very much like a business account that Kouri would have.
Okay. And are you aware that Eric was in the stonemasonry business, correct?
That's correct.
Okay. And so he was, on some level, assisting her in the remodel or
I
cleanup
don't
of
know
some
if
of
she
these
would
homes,
know
correct?
that.
That is not how I would term it.
I'm not saying financially. Are you aware that he was doing work on these homes?
I'm aware of one instance on the Franson Lane home in which he and Cody contributed about $133,000 toward the completion of the home, and my understanding is different than
Okay.
how you're portraying.
Okay.
Nothing further, Your Honor.
Nothing further from the forensic accountant. I don't know if we have any more witnesses. Oh no, I know that
Yeah, before we rest, we would ask that this be marked as.
The decedent's sister speaks at
Two
some
has not
point,
been.
but it looks like they are resting in the evidentiary portion. This forensic accountant was a great witness,
That's fine.
and I've got them very sped up, and they did a great job. She was very precise in her answers, but came across really neutral in how precise she was. Really, really well done. Very interesting stuff going on with life insurance.
Three on that. Ms. Lazaro, any objection to admission?
Interesting
States
stuff
Exhibit
going on
3
with the
solely for the
accountants,
purpose of this
accountants.
detention hearing.
Interesting stuff going on
Only to
with
the
life
extent that I have not
insurance.
been provided a copy of any of the jail phone calls that I could find last night when I was searching.
Do you have any of the audio?
No, that have been provided in discovery. So
All right.
I don't know what to do with that.
Well,
So I
out
guess
of
yes, I
fundamental
would.
fairness for the defendant, and without having to address the need to postpone or continue this detention hearing, I am not going to consider that phone call. States Exhibit 1 is in.
Okay.
States Exhibit 3, for the purposes of this detention hearing, is not.
Okay.
Okay.
And Your Honor, we have no further witnesses. However, we do have a victim impact statement from the victim representative.
And
I'm
if you
gonna
just name that person for us.
That's Amy Richins.
Amy, if you
I'm going to slow this down a little for the victim impact statement because it tends to be a little more emotional testimony than
don't mind stepping forward to the podium.
expert testimony. So this is the
Good morning.
defendant's sister. And I've slowed this
ahead.
down just a little bit. I
Dear
think
Judge Mrazek, I'm here today to represent my brother, Eric Eugene Richins, whose life was taken in a senseless act of poisoning on March 3rd, 2022. His wife, the defendant, has been accused of committing this crime. If she is found guilty, she has committed the ultimate act of betrayal. Eric is gone, and I am brokenhearted. He was my best friend and protector. The feeling of loss is so great it is visceral. And with the sorrow comes a wave of panic at not being able to see him again. I can never talk to him, never hug him again, and never more be a part of his life. Eric's world revolved around his family, his love for hunting, the family cattle ranch, and his intense drive as a successful entrepreneur. Being born into the Richins legacy shaped Eric's formative years and resulted in a lifetime of hard work, dedication, and fierce loyalty. At an early age, Eric learned the joys of keeping horses and cows around. He spent countless hours helping our dad work the ranch, hauling hay, feeding the animals, and mending fences. He loved our family unconditionally and was a devoted son, brother, uncle, and father.
just because I thought this question was really good, and I think a lot of people are probably thinking the same thing. Fifi asked, why is this allowed today? Should this not be allowed until the end of trial if she's found guilty? The impact, if whether or not Kouri Richins killed her husband, Eric Richins, is different than whether or not the impact to the victims need to be considered when determining pretrial release. So that's why we are getting into this impact statement. So that's what.
Eric was a family man who always strove to be the absolute best father and husband. He was an attentive and loving father to his 3 sons and a devoted husband to his wife of almost 9 years, Kouri, the defendant. Eric did absolutely everything in his power to provide his family and his 3 sons with every possible opportunity to learn, grow, and have fun. He was the coach or assistant coach on all his boys' teams, which included soccer, basketball, and baseball. He spent countless hours coaching and teaching the boys to play aggressive and give it their all. Eric truly cared about every single child he coached and wanted the absolute best for all of them. There was never a dull moment when you were around Eric, whether it was him showing up to a family dinner with no socks or the sleeves torn off of his shirt because he had to make an emergency bathroom stop along the way, or his calling to tell you he rolled the 4-wheeler for the upteenth time is stuck and he needs you to come get him. It was never boring. Eric loved to have fun and always wanted to make sure everyone else did as well. He owned almost every motorized toy possible, from 4-wheelers and side-by-sides to trucks and snowmobiles, and was so excited to share those with his sons. He had the perfect combination of business sense and foresight. He built a very successful masonry business from the ground up and helped many friends do the same. He had a special ability to build close relationships with everyone he worked with, which really allowed his business to thrive. Eric loved every aspect of his job, but most of all, he loved the people he worked for and those he worked with. Eric faithfully supported organizations that he truly believed in. He never was one that wanted recognition or accolades. He did most things anonymously and without recognition. Eric was a true champion of all people. It did not matter if you were an employee, friend, family, or the next random person walking down the street. If you needed anything, you could count on him. He truly cared about each person he met. Eric loved fully, laughed loudly, and lived life with reckless abandon. He enjoyed great adventures to far-off places, but also cherished the small and finer things in life. No obstacle was too great for Eric. He simply viewed each one as a challenge. No peak was too high, and the next adventure was always just around the next bend. Words cannot describe the loneliness and loss that is felt in every heart that was lucky enough to know him. Eric was such an inspiration and role model for us all. His loss has created a Grand Canyon-sized hole in this community. Except instead of taking millions of years to slowly form, our worlds change overnight. His 3 boys' entire worlds and their perspectives on life changed. None of our lives will ever be the same. Eric died under horrendous circumstances. I am tormented at the thought of what he endured. I play it out in my mind. I go through the terrible sequence of events.
Don't do that.
I wonder when he realized he was in mortal danger.
Don't do that.
I wonder what Kouri may have said to him in his last moments. How long was he conscious, knowing he would die? Where were Eric's boys when all of this happened? Did they hear Eric's body fall to the ground? Did they catch a glimpse of their father taking his last breath? It's torture to think of. Why did Eric lose his life? Why did the boys lose their father? Was it because of Kouri's greed and desire to get life insurance and other assets? If so, that is abhorrent. How could anyone value human life so cheaply? I cannot comprehend it. I'm overflowing with grief and pain at the thought that Eric meant so little to her. If Eric had died because of an illness, he would have been cared for. He could have looked after him and been with him. If he had died because of an accident, people would have tried to help. There would have been kindness. But there's no comfort to be had here. There's no consoling thought in the way Eric died. In his last moments, after being intentionally poisoned, he was faced with betrayal and terror. The thought of it is unbearable. I am haunted by the horror of it. This last year has been a living hell for our family. We have watched as Kouri has paraded around portraying herself as a grieving widow and victim while trying to profit from the death of my brother.
Those are strong
Both
words.
by trying to profit from a book about his death and trying to get life insurance and assets that should go exactly where Eric wanted them to his boys. Immediately after Eric was killed, Kouri told us she could not help us get anything ready for the funeral as she was too distraught with grief. We shortly found out that was not true at all. In fact, she pulled herself together enough to go close on the purchase of a $2 million home, hire a real estate agent, hire an architect to create CAD drawings of the home, hire a lawyer in order to file a lawsuit on Eric's trust, hire a locksmith to come break into and clean out my brother's safe, and attempt to have Eric cremated.
What?
She mustered out the strength and resolve to do most of this within 48 hours of his death.
What?
Kouri assaulted me. I will never forget the look in her eyes when she attacked me that Sunday morning.
She just said Kouri assaulted me. There was a lot of information there, but the sister just said Kouri assaulted me. I'm going to make myself smaller. I want to hear exactly what this sister has to say.
It was early and had been snowing most of the night. I was just getting ready to leave and heading out to the car when I saw a locksmith in Eric's detached garage starting to drill out his gun safe. I asked Kouri multiple times why we could not just call my dad for the code. I could not understand why she was breaking into and ruining Eric's safe. To this, she screamed at me at the top of her lungs, called me some inappropriate things I cannot share with you here, and then told me to get out
Oh, girl, you can share them in court. I know it's Utah and all, but you can share them.
of her house. It was then that I told her that she could not kick me out of my brother's house. My sister Katie was now the executor of Eric's trust and estate, and just like Eric, she would not want the defendant breaking into his gun safe. Kouri looked at me with pure hatred and rage. I was messing up her plan. I was getting in her way, and because of that, she attacked me. She punched me in the face and neck multiple times. It took 4 people to pull her off me that day.
Holy shit.
Before the funeral, Kouri opened a bank account and asked everyone that was grieving to send her money instead of sending the family cards and flowers. It was not even 2 weeks after Eric's passing that we were told she had taken down all but one photo of my brother and removed all his clothing from the house. Kouri put together a golf tournament in Eric's name 2 months after his death on what would have been his 40th birthday and told his family, all of us, that we were not allowed to attend.
Yikes.
Since Eric's death, it has come to our attention that Kouri took out multiple life insurance policies on Eric without his knowledge. It appears that she forged his signature on various documents, assigned herself as Eric's durable power of attorney, inappropriately diverted money from his business to herself, and assigned herself as beneficiary of Eric's portion of our mother's retirement account. I should also not
This is why they hired a forensic accountant.
forget to mention the multiple life insurances she has taken out on the boys.
What?
Her most recent business venture was authoring a children's book about how to help grieving children cope with the loss of the death of a parent. In this book, she had the audacity to use the boys' real names and even use their last family portrait. Her behavior gives me great concern, as she has exploited the boys for money and will likely do so again. In addition, Kouri has weaponized Eric's children, manipulating my dad to do or not do things by threatening to cut him out of their lives if he did not capitulate to her demands. She similarly deprived the boys of contact with myself, my sister, and her daughters, unless we agreed to give her the money in Eric's trust. Money that Eric wanted to go to his 3 children. As if that were not enough, I've been told that Kouri started telling their 3 little boys that none of Eric's family or friends loved them.
Oh, shit.
She apparently told them none of us cared for them or wanted to be around them, even though that is the exact opposite of what was happening. We all want nothing more than to be there for those 3 little boys, my nephews.
Where
Yet Kouri
are
has
they
made
now?
sure to cut us out of every aspect of their lives. This is all just a brief summary and the start of what our family has been through over the last year. We have scarcely gone a day without finding out some new allegations or evidence regarding something Kouri appears to have maliciously done to attack and undermine my brother, his 3 little boys, and our family. We have all been there since the beginning of Kouri's and Eric's relationship. I was there on one of their first dates. We were there at the wedding. We were there when each of the boys were born. We have been there for every birthday party, school graduation, and rodeo. We welcomed her into our family and treated her as one of us. Not only did she betray our brother, it feels as though she has murdered and taken away a part of our souls as well. Because of her actions, there has not been a day that has gone by we have not lived with paralyzing anxiety and fear, worrying for the boys' lives as well as our own. I may be naive, but I never knew evil like this existed.
Okay, well, we
If
know
Kouri
how
was
the
in
sister
fact
feels.
willing to kill Eric for money, who's to say that what she will not do? Who would be next? Kouri was in a desperate financial situation when Eric was killed, and that situation seems even worse now. We understand that she has defaulted on loans and is already a defendant in other lawsuits based on her financial misdeeds. I am truly concerned that she will stop at nothing to dig her way out of the problems, including murder. She seems devoid of moral sensibility, and there is no telling what she will do
And
if she
that's
is released.
why this is coming up at a
Judge
bail
Mrazek,
hearing.
her fate lies in your hands. Please do not allow Kouri to use the fraudulent life insurance proceeds to get out on bail. That would be morally reprehensible. Please do not allow Kouri to take advantage and make a mockery of our justice and legal system anymore. She has done enough. Please do not allow Kouri to hurt Eric's memory, our family, friends, and community anymore. We have been through enough. Please do not give Kouri the opportunity to hurt Eric's 3 boys anymore. They have lost enough and have been through enough. Since Eric's death, we have learned and unfortunately are continually reminded that Kouri is desperate, greedy, and extremely manipulative. If she gets out on bail, I will be afraid not only for my own life and those of all of my family, but most importantly for the lives of Eric's 3 sons. Our family has already suffered enough. Please do not let Kouri out on bail where she will be a risk to do further harm. Please protect what Eric put his life on the line for, his 3 boys. Thank you.
Amy, thank you.
And the reason
Ms. Cassell?
Nothing further now.
Okay.
the reason this
Ms.
is coming up at a
Lizarro,
bail,
is
and
the-
I am still a little bit sped up. The reason this is coming up at the bail hearing is because the safety of the community is part of what the judge is going to have to consider. But what she just laid out, well, we know the sister clearly thinks that Kouri killed her brother, Kouri's husband, and the court has to consider whether or not they will let her out on bail. I'm interested in the
Defense
judge's
calling any witnesses?
statements.
I am not. I guess what I'd like to do is just largely have the court review the briefing and the attached exhibits be submitted and considered as
I'm
part
not
of this,
surprised
but I
there's
don't
no
intend to put on any
defense
further
witnesses.
All right. Would you like an opportunity to make any closing argument for today, Ms. Lizarro?
Yes.
Why don't we have defense go first, and we'll just give the state the last word.
Thank you.
Okay.
So the defense is going to wrap up their position
I guess I'd start with
for bail.
Whether or not the court has any specific issues they would like me to address.
No, I mean, candidly, there's a threshold legal issue here, right, that comes out of
I appreciate that we have this on film and that these hearings are streamed, but I also don't need to be intimately familiar with every single attorney's pores. It's so distracting. I am
the
distracted.
briefing, and the state has been candid about the pending Barnett case. I listened to the oral arguments
Correct.
before the Supreme Court. I think the state is wise to request a ruling in the alternative, but I'm persuaded by the defendant's position that as a matter of law, while a defendant charged with a capital felony supported by substantial evidence does not have a right to bail, they can nonetheless request bail and the district court retains discretion, at least under the current status of the Utah Code, to consider the request. So fast forward past that.
I will do so. And
The court,
don't necessarily disagree with what may or may come up.
what the court just said is there is pending cases on whether or not a court can absolutely deny bail, but the law at the time says, or the law now until the Supreme Court in Utah decides, the law says that a defendant of a capital crime like this does not have a right to bail. So the defense is fighting an uphill battle.
Of that case that's up on appeal. With regard to the sufficiency of the evidence, I mean, we're here because of a really tragic circumstance, and I don't think any of us want to forget that. I mean, especially my client. She loved her kids, she loved her husband, but she's also
She said loved her
charged
kids.
now with his murder.
Not loves, which is interesting.
And so I just don't necessarily
just
want
be a
that to
slip.
get lost on the court, that we understand the gravity of the situation. With regard to the evidence, I'm going to skip through most of it. I think the most important thing, if she poisoned him, is did she ever get it from CL? Was it ever requested from CL? I don't think the state has been able to draw that nexus. I don't disagree that CL was buying drugs. I think that's clear. She has a history of being a drug distributor. She was jammed up on 4 first-degree felonies. She had a potential federal case hanging over, and then when they look at her phone, they find evidence of additional drug distribution as an entirely new charge. Pursuant to essentially the detective's testimony, is they walked her down the line of, I need more evidence, this is what we need to know, and provided evidence to her essentially until she got it right, and then she was released. When we look at the cell phone mapping, yes, we know that she went and picked up a check, we know that she was cleaning houses, we know she cashed a check, we know she picked
that
up
cell phone
drugs.
mapping doesn't mean that she's distributing
But
drugs like
can't
they
put her
say.
anywhere in the same vicinity of Kouri's phone. Because apparently the mapping's not available from Verizon, which somewhat surprises me, given it's Verizon.
I think it's a length
But-
of time between the events and the request.
Correct. But they have corroborating evidence for all the things about her buying and selling fentanyl. They have zero corroborating evidence for anything related to Kouri requesting it, her giving it to Kouri. She didn't tell anybody that she was buying it for Kouri. She never had anybody with her when she dropped it off. There's nothing to make the most important correlation in this, and that's that it was ever provided to Kouri, that Kouri ever requested it. There was no fentanyl or traces of fentanyl found in the home anywhere. And I think that's significant. I think if she had gotten 30 pills on at least 2 separate occasions, that's a
Where
lot
did
of
they
fentanyl.
go? Yeah, she's like,
I
where'd the
mean,
fentanyl go?
if one's lethal, right, we're talking about a
Your
lot
client's
of
being charged with
fentanyl, and
distribution.
nothing is found, no traces anywhere, absolutely nothing. So I think the state's making a big leap in their evidence by saying, look, we have this girl, we know she's a drug dealer, we know she's buying fentanyl, but there's nothing to corroborate anything she says that ties it to Kouri. The glass, Kouri tells them she made him a drink, right? The glass is there. No one thinks to bother to
Do we
Where's
see
the
it?
evidence that the glass is present?
Correct.
well, they didn't look for a glass, I guess is what I should say.
Okay.
She said the glass was there, and the court and I had the exact same question at the same time. Who sees it? Who sees that the glass from the drink that was made was there? Or in all that motion with the phone, did it get cleaned up and put away? So they couldn't test it. Otherwise, they might have tested it.
So no glass was tested. So there's nothing to show that Kouri did anything to Eric. And by Detective O'Driscoll's testimony, it could have been accidental. I mean, it very well could have. And I think that, given the evidence presented today, is a very plausible situation. Being bad with money does not make you a murderer. Being bad at
I have no idea if she was
managing
actually
your
selling
accounts,
fentanyl. She's charged with it.
Makes you bad at math, but it doesn't make you a murderer. The other thing I think that's significant is by the testimony that came out today, the hard money loans that she owed, at least, far exceeded life insurance policy that was paid. And so even getting the life insurance money was not going to solve Kouri's problems, not even
It's a very
close to
Murdaugh
solving her
argument.
problems. And so that evidence
Your Honor, the
alone,
murder doesn't
while,
solve the financial
maybe
issues.
there's some other issues
That doesn't make sense.
with Kouri's business. There's nothing to tie it to her having any motive or in any way being in a better position from Eric's death. In fact, she's in a worse position because of his death, because Eric had a business. He was continually making money. He was, from what it sounds like, the one putting the majority of the contributions into the joint account. So his death, from a financial perspective, has harmed her far more than any money that she gained from any life insurance. With that, I'll largely submit on the remainder of our briefing.
Yeah, there's not much
I
else
trust
to
the court has been through it all.
I have, carefully. Thank you. Ms. Cassell.
Thank you, Your Honor. With respect to the no corroborating evidence, there's a lot of corroborating
She wanted
evidence.
to say
that corroborates
mountain.
CL's
She backed it up.
She.
Thank you
It's
for not going to mountain.
And I think one of the things that we have that's said is, that she was primed and told what to say. But what really happened is she's, a year later she's asked to consider what, if she remembered anything else, and she came back with, I remember more, and that's very typical of witnesses. It's typical of people that we have testify.
It's typical of humans.
You heard all of the corroborating evidence, Your Honor. The matching with the cell phone records, matching with the mapping. Do we have CL putting the drugs in Kouri's hands? We do. We have a hand-to-hand that was testified to. So we have the evidence that Kouri got, or the defendant got the drugs. We also have the evidence that corroborates all or most of CL's story. We would have more if there weren't texts that were deleted. We have a great deal of information that was deleted, and that was deleted off of the defendant's phone. So I think that
is part of it.
Sufficient evidence just for CL, and that makes CL credible. This idea that no glass was tested, well, if you look at the pictures that we have submitted, there's nothing there. It's a stage scene. How they can argue that Eric somehow consumed this himself? There's no glass, there's no baggies, there's nothing there that indicates that this was ever taken, the fentanyl was ever taken by Eric. And also to say it's accidental, 1 or 2 pills might be accidental. 20 or 5 times the lethal dose is not accidental, Your Honor. That is someone who wants Eric dead. And the person who benefited the most from Eric being dead is the defendant, or the person who...
This is what I said. Look, if she brought him a drink to go to bed into the bedroom, and he took fentanyl with whatever drink or was whatever to swallow those pills, there would be a bag there. This scene, from everything that's been described, does not match what you would see at an OD. It does not match that at all. And there's no way she wouldn't, if you clean that up, you tell the police. So and normally in OD scenes, you don't see that stuff moved. You still see the pills or whatever there. And that is pretty telling.
Thought she was going to benefit the most from Eric being dead is the defendant. She thought she was going to be entitled to Eric's estate. She didn't know that there was this trust that had put the money into Kouri Richins' name. So she's the one that thought on the day that Eric died that she was the one that was going to benefit. She benefited from the insurance policies. She thought she was going to benefit from more, and she thought she was going to benefit from Eric's estate. She tried to benefit from the other life insurance policy on Eric's business. That didn't happen. She also was in dire financial straits, Your Honor, writing checks on closed accounts or checks with no money in them. I know you cut me off, but that's significant.
It was in your brief.
Thank you. I understand.
But like you'd already
that's
tried
significant
that water.
because she was in dire financial straits. She was deep in debt, and the way to
This judge straight up said this is not a trial on the financial crimes. We're here on a murder bail hearing.
get out of that debt was to kill Eric Richins. She benefited financially, and she had many cases, and we talk about this all the time. Prosecutors say we don't need motive. This case has motive. This case has motive that she needed to get out of this debt, and that's the reason she killed Eric, in hopes of getting his estate, in hopes of getting his life insurance policies, and that, Your Honor, we believe is substantial evidence.
That is substantial evidence. I'm interested to see what the court says. All right, Your Honor. Whoa. We're going to get to know what color your eyes are, how dilated your pupils are, what you had for lunch. Laura
The issue before the court
You are right.
is whether defendant Kouri Richins should continue to be held without bail during the pretrial period.
I have this sped up a little bit.
Defendant is charged, among other crimes, with aggravated murder under Utah Code 76-5202 sub 2. To convict defendant of this charge, the state must prove beyond a reasonable doubt at trial the defendant intentionally or knowingly caused the death of another individual under any one of the following circumstances: for pecuniary gain, or by means of the administration of a poison or of any lethal substance. Under Article 1, Section 8 of the Utah Constitution, a defendant charged with a capital offense has no right to bail if there is substantial evidence to support the capital charge.
And that's why we're here, to hear
And
the
under Utah
substantial
Code
evidence.
7720-201 sub 3, a charge of aggravated murder is considered a capital felony for the purposes of determining bail during the period before the state makes an election whether to file a notice of intent to seek the death penalty. Accordingly, at this time, the aggravated murder charge in this case is considered a capital felony. Moving to the substantial evidence inquiry, having considered the evidence offered by the parties, both through live testimony today and by documents attached to their briefs, which the court has reviewed at length, and having had the opportunity to weigh the credibility of that evidence, the court determines the state's evidence, notwithstanding contradiction by defendant's evidence or arguments, could support a reasonable jury reaching a guilty verdict on the charge of aggravated murder. Indeed, a jury could reasonably choose to rely on the state's evidence regarding means and motive and consciousness of guilt, which includes evidence showing that Eric Richins died of fentanyl ingestion, that he was not known to be a user of illicit drugs other than the occasional THC gummy, that defendant purchased 15 to 30 fentanyl pills from CL approximately 1 month prior to.
The court is making a finding for the record saying this is why there's enough evidence at this point to hold this defendant without bail. This is the evidence that a jury could conclude that he did not accidentally overdose. This was not an accident.
Eric Richins' death. Cell phone mapping confirms, or at least indicates to a reasonable jury, that CL's phone was near the Maverick and Draper on February 11th, and that while there, CL's phone made calls to acquaintances, capital A acquaintances as listed in the testimony and the information, and sent texts to defendant Kouri Richins, and that CL's phone then traveled to Francis and then returned, or was in Francis and then returned to Heber. We have CL's sworn testimony that she handed the fentanyl that she acquired to Kouri Richins in a hand-to-hand transaction in her driveway. We also have motive. At the time of Eric's death, defendant knew how the premarital agreement would operate, but was not aware that Eric had changed his estate plan. So at the time of Eric's death, defendant's subjective understanding was that she would get a greater share of the marital estate if Eric died during the marriage, as opposed to what she would receive under the premarital agreement if the parties divorced. Moreover, evidence admitted in the case shows that in the months leading to Eric's death, defendant's personal and business accounts were overdrawn. She was making significant recurring debt payments, many of which were to hard money lenders, and that her lines of credit or lines of credit available to her were maxed out. And at the time of his death, Eric's life was insured for approximately $1.2 million, not including the policy related to the buy-sell agreement, with defendant listed as the beneficiary. Moreover, we have evidence from which a jury could reasonably infer consciousness of guilt. We have evidence regarding the search history that was extracted from defendant's second phone after her first phone was seized. And we have inconsistent statements made by defendant as compared to other evidence in the case regarding whether she called 911 immediately, whether she performed CPR, whether she did something else for the 15 minutes between discovering Eric dead and calling 911. In considering this evidence, a jury could reasonably choose to discount and find unpersuasive defendant's efforts to poke holes in the state's case, and in so doing, a reasonable jury could reach a verdict of guilty beyond a reasonable doubt on the charge of aggravated murder based on the state's evidence.
Like it could happen.
For these reasons, the court determines there is substantial evidence to support the capital felony charge of aggravated murder against the defendant in this case. Having made that determination, the court considers whether it has discretion to grant defendant bail, notwithstanding that she has no right to bail under Article 1, Section 8 of the Utah Constitution. And having considered the arguments and authorities cited in the parties' briefing, the court determines as a matter of law that in the case of a capital felony that is supported by substantial evidence, while a defendant does not have a right to bail, the defendant may nonetheless still request bail, and the district court has discretion to grant bail if the circumstances warrant doing so. But the circumstances of this case weigh soundly against granting pretrial release of any kind.
He's like, that's a big
First,
old nope.
defendant is charged with aggravated murder, which carries the possibility of sentences as severe as the death penalty and no less severe than an indeterminate prison term of 25 years to life. The severity of those sanctions, the severity of the sanctions that follow a conviction for aggravated murder, creates a powerful incentive for a defendant to resort to desperate acts that might include harming themselves, harming the members of their family, or harming witnesses in the case. Because an incentive this powerful cannot be adequately managed in the community, it weighs heavily against granting any form of pretrial release. Second, the state has offered substantial evidence that defendant procured fentanyl on more than one occasion, and on at least one occasion, deployed that fentanyl to cause the death of another person. As a general matter, an individual who is capable of this kind of decision-making is not a good candidate for supervision in the community. More specifically, given the uniquely dangerous nature of fentanyl, which has been demonstrated tragically by events in Summit County, defendant's alleged conduct, as supported by substantial evidence, is especially dangerous. Indeed, these circumstances constitute clear and convincing evidence that defendant would pose a substantial danger to the community if released on bail, a substantial danger that cannot be adequately managed by any combination of conditions of pretrial release that are available in Summit County. For these reasons, the court finds the circumstances of this case, as supported by substantial evidence, weigh soundly against any form of pretrial release. The state's motion for pretrial detention is granted. Defendant Kouri Richins shall continue to be detained without bail during the time she awaits trial or other resolution of the criminal charges against her. Ms. Richins, you have the right to an expedited appeal of the court's ruling today. You must file a notice of appeal within 30 days of the court's ruling, and you have the right to be represented by counsel on that appeal. Let's pause there for a moment. Ms. Cassell, any questions?
No, Your Honor. Thank you.
Ms. Lozara,
No, Your Honor, thank you.
where do we go from here? Are you
Prelim.
prepared to set a preliminary hearing?
I don't think so, because I think just based on the state's briefing and evidence provided, there's a lot of stuff that I don't have yet, and probably need experts to look at, especially with regard to the phones.
Okay. What is a reasonable time to set a scheduling conference, understanding that I'm going to push counsel to move this case as fast as possible, given that Ms. Richins is in custody?
I understand that and appreciate it.
He's like, yeah, I know you want stuff, but I want a prelim date. I like that. I like that. I like that.
I guess that question should be posed to the state as to when they think they can get me things. Like, I can't prepare without the evidence. I'm, you know.
Your Honor,
I'm at their
if they
mercy
don't
at
do
this
their
point.
job, I
Can
cannot
we
do
check in on
mine.
the 26th, just so you can tell me whether you think you've received everything the state has?
I will, yes.
Do you want to do it in the morning or the afternoon?
Let me look.
26th of June?
Yeah.
Everything's
But
on
you
the
know what?
26th
I'm
of
looking at the
June.
wrong. I'm sorry.
That's a Monday, Your Honor.
You're right. You know what, though? That's probably okay. Let me take a look here, folks. 1 second. What's that? You're right. That's not going to work. Okay.
The clerk is like, no, Your Honor.
We can. Can you get stuff turned around that quickly, Ms. Cassell?
Well, we.
You believe you've given it all.
We have. Yeah,
Okay.
we have everything that we have, we put in our.
Well, we're going to find out. June 23, Ms. Lazara?
I'm out of town as long as I can appear via WebEx.
It's fine.
And I don't know that we need Ms. Richins if we're just going to set it as a status.
But she has a right. She doesn't have to be in the courtroom if she doesn't want to be.
She wants to be in court.
Can we do it
You
the
know she
30th
does.
instead then? So I
You
can,
can't. I'll be out of town. You want to go to the 7th?
no.
No, that's the week of 4th of July, Your Honor. Nobody wants to do that. This is, you want to know why criminal trials
We can
take so
also-
long? You want to know why court takes so long? This is why court takes so long, especially in the summer. Can we do it this day? No. Can we do it that day? No. Picking a date is one of the most difficult things to try to find everybody available. It's so hard.
Special set.
I'm sorry, what else do you have?
No, it's fine.
Me trying to get an appointment for a facial. What else you got? I need a date. No, not that. I'm
Midday
screaming.
on the 22nd?
I'm at VidCon, Your Honor. Can we do it the
yes.
following week? I'm
Ms.
back.
Cassell?
That's fine.
All right. Noon on June 22 for a scheduling conference. Would you like that to be by WebEx, Ms. Lazar?
No, I can come in person.
All right.
That's fine.
Very good. June 22 at noon.
I'll cover it when I get back from
here at
VidCon.
Courtroom B. Ms. Lazaro, anything else on the record today?
No, I don't have anything further. Thank you.
Ms. Cassell?
No, Your Honor, thank you.
All right, ladies and gentlemen, we're going to do this in an orderly fashion, and we're going to do it in stages. I appreciate your patience.
The courtroom
Just
is very
listen to the
full.
deputies. Everybody in front of the bar, sit tight. The deputies are going to clear the gallery one section at a time first. Please just sit quietly
I'm gonna just
and let them
mute.
do their job. Thank you.
Moot.
Your Honor,
I'm going to
mind if
mute.
the crossline goes with the...
That's fine, of course. Thank you.
I'm gonna
Otherwise,
mute
the
this.
court is in recess. I appreciate your patience this
We
morning.
can let
Ms.
everybody
Richins,
file out.
I wish you the best of luck. I'll see you back on June 22nd. Thank you.
I like this judge. I like the attorneys in this case. Y'all, I'm glad you asked me to cover it. We're just going to watch. We're going to watch everybody. Come on. That's so dramatic. We're going to watch everyone file out of the courtroom if the camera stops focusing on the dramatic zoomed in shots. I'm going to get through some of our questions because you've got questions. I've got questions. We've got questions. It's time to fact around. Why did this just go dark? All right. Well, I guess there's nothing else left. So we're done. All right. We've got questions. So it seems like the motion practice on this was chock full of information. So what I'm going to do is pull those, synthesize those, and then make do a podcast episode where we synthesize everything that the state is presenting and the arguments the defense is presenting. Rob, I enjoy this cameraman's previous work on Dramatic Squirrel. The camera zooming was so dramatic, and it was so, like, the big swoops were so fast. It's much different than when you have the court TV cameras set up for trial and then the camera kind of pans this way. Much, much more dramatic. So, wow, that was quite a hearing. This is a new case to the docket. Look, financial motive for murder is apparently something we cover on the channel now. So here we are. The arguments gave Murdaugh, and I wasn't expecting that. I wasn't expecting the defense to come in with, but she's worse off with him being dead. That's exactly what Murdaugh's attorneys argued. Look, Alec didn't benefit from the death of Maggie and Paul. It's very interesting to see. And when we talk about patterns in criminal law, I know that this exists just because that's where I practiced. But for y'all to get to see it and be like, oh, the arguments are kind of following these patterns. It's like in just simple drug possession cases, how many times you see somebody say, but Your Honor, they weren't even my pants. It's like, who comes up with that? You know, half of the DUIs you see, it's like, but I only had 2 drinks. You just start seeing these same excuses over and over. And this is one of them, but they didn't benefit. So they're not the one who did it. So now we'll get to see that play out in this case as well. The sister's testimony, well, it wasn't sworn testimony, it was a statement. The sister's statement to the court was very telling. I think we will see a lot more information. I'm going to go through the motions because there's more information that I'm aware of that didn't come up here, where the deceased husband had gotten violently ill after this defendant had made him other things. And that seemed to be the impetus for why he put everything in a trust that she did not know about. And there were statements to family that's in the motion briefing that we haven't seen, statements in the motion briefing to others that he thought she was trying to poison him. So if this goes to trial, it's going to be a very interesting trial. And we're going to cover it from the beginning. We're going to add it to the docket. I don't know if there will be as much motion practice as there is in Idaho. The pre-criminal trial motion practice in Idaho has been so busy, and we have a lot to catch up on. In short, my weather has cleared. So our severe weather has passed. Do we already know if this trial will be streamed? No. We don't even have a date for preliminary hearing. I hope there's a public preliminary hearing. It'll be a lot of what we just saw, hopefully with a different camera setup. So
Question, do you think you'll cover the Brittany Dawn lawsuit since she settled? I covered the Brittany Dawn lawsuit a million years ago when it was filed. I covered the fact that it settled. There was no settlement agreement filed yet, so we don't know the details of that. I will circle back to it when we have time, but I did cover it before. What panel will you be on at VidCon? I will be on a panel on Friday. It's at like 10:30 in the morning. It's a creator track monetization panel about communities with Anthony Padilla, myself, and 2 other creators. So Friday at like 10:30 a.m., I think room 204. I will share that on socials too. I have the title of the panel. I just don't remember off the top of my head. It's a panel hosted by YouTube. So YouTube invited me to be on that panel. I'm really excited. Will you please cover the Delphi case? I have not decided yet on the Delphi case, so I don't know. Megs, I'm sorry. My stepmom-in-law was murdered. I was super close with her. I want the defense to give their all so we get a good conviction if they did it. I think that's tremendously fair, and that is something that you want to see. Interlocution, I hope I said that right. I might not have. Our family dealt with false accusations. I want to stress the value of defendant rights to a fair process. A false conviction is not justice for anyone and creates an additional victim. Agreed. Absolutely agreed. And thank you for sharing your perspective. And this is why we have the rights that we have. We want to make sure, or at least our system was set up to make sure the best that it can. I'm not saying it's perfect. The system is set up to try to make sure that the people being convicted and having their liberty taken by the state are the people who did the crimes. That is the goal of the system. That is the goal, is to do that well. Is that always done well? No. Is it better than a lot of other systems? Yes. Now I completely understand why some families put out there they have the right to sue. I'm not sure what that was referring to earlier, but Midwest Girl, thank you. I wonder if KB is going to be another AH and tell her lawyers how to run the case. I have no idea. Civil cases are much different. Question, Emily, can they add charges after the indictment? Is that what these motions are for? I'm confused. This is regarding Kohberger. No, they can't add charge. Well, there are limited circumstances where they can add charges after the indictment. I don't think that's going to happen in the Kohberger case. So I don't think there's anything to add. So bless the ADHD friendly commentary and Q&A. You're welcome. Sophie, they had to wait to get really concrete evidence that couldn't be refuted before arresting her. I think that's true. I just wonder if she was always the target of an investigation. I'm going to look at the motions. I need to know more about the case. And I need to know more about the case. And that's where we're at. So I'm curious as to if they always suspected that, given the amount of fentanyl in his system, given the fact that there was nothing to indicate an OD in the crime scene when EMS showed up. I wouldn't be surprised if they were always keeping this open, and that's why she expected to talk to law enforcement. Laura said, please check out the Scott Peterson trial. The defense lawyer has been admonished multiple times. Trial has been spicy. Really want your take. I know that the Scott Peterson trial is going on. I knew that there's multiple trials going on right now, but knowing that I'm taking a week next week to go to VidCon, there was no way I was going to get into trial coverage and then back out of trial coverage with knowing that I have obligations elsewhere next week. I might take a look at kind of the attorney's moments down the road. I did not want to cover the school shooting trial too closely. I find school shootings to be tremendously difficult to cover. They are horribly sad. And so I might go back and take a look at moments with the defense attorney, but I don't plan on covering it day in and day out with that. The Lauren said, I've been tested for ADHD and I'm currently on medication for the first time in my life for ADHD and anxiety. This is all because of Emily. No, it's because of you, Lauren. You took the steps and went to do it to take care of yourself. And I am so proud of you. If our open conversations about ADHD helped you recognize something in yourself, I'm so proud of you for saying, hey, it's me. Because you did that. Trying to make an appointment and go through all the testing, especially when you have ADHD, is exhausting. Like, the reason people are not diagnosed with ADHD is because they have ADHD, and getting an appointment to get diagnosed with ADHD confounds the ADHD reality. It makes it so hard. to go and get it done. So I get it. Are you still considering the Sarah Boone case? Yes, I am. I absolutely am. Lawyer you know is doing videos on Scott. Lawyer you know is doing videos on everything. He is so busy right now. What is the likelihood the Kohberger case will be delayed 2 to 3 years? I don't think it'll be delayed that far at this point, but I don't think it'll go to trial in October. Christine asked, can this hearing be used in trial? Kind of. If there are contradictory statements, like if that same officer testifies to something contradictory, it can be like, well, at this hearing, you said this for impeachment purposes, but that's really it because the rules of evidence don't apply the same way at this hearing. So some of the stuff's not going to come in the same way. Question, can Kouri use money she inherited from her husband for her defense in his murder case? Yes, she can. And there's not much they can do to claw that back unless they find that those insurance policies were fraudulent in some way. And then we end up in a civil realm like we are seeing in the Murdaugh case where the insurance company is like, no, you owe that back to us. J. Michael says, please say hi to Jade. She loves your purple hair. Hi, Jade. Thank you. I just got it touched up to go to VidCon. We had to be purpley purple. Moo Boy Moo said, welcome back to Utah, y'all. It's so interesting to hear a case and be like, I know that, Maverick. It makes this case feel more real that it's this close to home. And I imagine that's how most communities feel when you're like, oh no, I know exactly where that is. For me, it was one of the weird things being a prosecutor in an area where I lived. It was like, oh, I go to that Rite Aid all the time. Or, oh, hi, yeah, we went to high school together. I'm going to give another DA this prosecution to handle. That's a little too close for me. Question, why does all this matter for a bail hearing? Claire, I think we saw that at the end. The prosecution needs to show that there is substantial evidence. So the prosecution was showing the evidence they have that connects this defendant to the crimes, saying, hey, a jury could convict this person. So here we go. So I asked my daughter in Knoxville for DPT school if she's getting storms. She said she didn't believe so. We got them through Middle Tennessee, but the weather in Tennessee is way different. I mean, Knoxville's in a whole different time zone and all of it. Emily, you have no idea how much you help people. You're incredibly kind, and this is the best group of people. The Lawnards are absolutely the best group of people, Sonia. I really feel that I just put some parameters and ask people to be kind and compassionate with each other, and y'all show up to that task and go, that's me. I would like to have kind conversations on the internet with people who also want to have those conversations. I feel like if I do anything, it's holding a little bit of a safe space here and protecting that, and that y'all show up for the hard parts. Y'all show up to do that. And that's incredible. I just like to talk about nerdy shit in law. She took out multiple policies on the kids. Yeah, that scares the crap out of me. Really, really does. Or her attorneys appointed. I don't know, but I bet I can answer that. I pulled up one of the motions. This looks like a private law firm. They are not public defenders. This looks like a private law firm. However, I will say that private attorneys can be appointed by the public defender's office or be appointed by the state in certain circumstances. So in this case, there might be conflicts that the public defender's office cannot deal with because we already know CL is pending multiple charges for drug distribution. So if the public defender's office represents CL, then the public defender's office has a conflict to represent Kouri Richins because CL is a witness against Kouri Richins. So it could be that they are panel attorneys that are private attorneys that are appointed by the state. That is a possibility. They could be privately retained. I don't know. So don't know yet. Haven't looked into it. So maybe. She thought she would get his business because she didn't know he put it in a trust. After she made an earlier attempt to poison him, he told his family he thought she was trying to kill him. Look, if you feel like someone is trying to do that, trust your gut and run. I know that's hard when you have kids and have to deal with the divorce and are afraid. But that is what I think the motions will show us. Brianna said, if she is denied bail, does that mean the judge thinks she's guilty? The judge thinks, the judges generally don't go in thinking someone's guilty or not. The judge thinks there's enough evidence that a jury could find that at this point. And that's what that means. It means that on the law, the judge thinks there's enough evidence based on what was shown. I'm sorry it was me, or does this judge look like Chris Watts? I don't know what Chris Watts looks like, so I don't know. The sister's statement was impactful. Yes, it was. Very, very, very much. Is the defendant allowed to see her kids while in jail? If her kids are witnesses, no. If the kids are with her husband's family, I also imagine they will not let the kids see her. I don't know if a guardian ad litem has been appointed for the kids. I don't know the legal situation with the kids, so I don't know. We will see. I'd guess not eligible for a public defender due to real estate assets. Not necessarily, given the state of the finances that we've learned about. It seemed that she was in a substantial amount of debt. But if she did get over $1 million from life insurance, then she might not be eligible. It just depends. But yes, it does seem that she hired them before there were charges. It doesn't mean they might not be appointed later, but we heard the defense attorney bring that up in cross-examination of the officer, saying, but you talked to her, she was represented by counsel. But she hadn't told law enforcement that she was represented by counsel. If you have a lawyer and somebody comes to talk to you, the first thing you say to them is, I have a lawyer. If you don't have a lawyer, then you say, I would like a lawyer. No, I know who Chris Watts is. I just don't remember what he looks like. It is not a case I've spent a lot of time on. So off the top of my head, I don't know if he looks like Chris Watts. So anytime they think there's enough evidence, you cannot get bail. No. A, we're in Utah, and B, it's a capital case. So if they think there's enough evidence in a capital case, the defendant does not have a right to bail, and then they would have to show more bail. But that can be done depending on the case. So it really depends. But no, on a capital case in Utah, the defendant does not have a right to bail. That changes jurisdiction by jurisdiction. So in some cases, you have a presumptive right to bail, and in some cases, you don't. Murdaugh had bail. I mean, it was set at $7 million, but Murdaugh had bail. So there's also other things that are considered. And the bail standards and what's considered for bail vary jurisdiction to jurisdiction, actually quite a lot. So bail is a really specific thing on the type of crime, the person the defendant is, the record that they have, the circumstances surrounding the crime. It's quite a lot. So, with all of that, it has been 4 hours. That was a lot of a hearing. I have to go do kiddo pickup because it's summer and my time gets a little like, tomorrow, we have a members only live stream. We're going to start talking about the behind the things for VidCon. So if you're a member, you will get to be a part of all of the behind the scenes things for VidCon. I'm going to be filming the behind the scenes lounges, some of the different creator events that we are invited to, those sorts of things. So get ready. Get ready for that, members. We will be talking about that tomorrow. For everyone, I will not be streaming next week. I will miss you dearly. I'm sure you will miss me too. I will just miss our little chit chats. There will be a new podcast episode next week. It was supposed to be about Rust, but there is other stuff going on, so that is subject to change. We will see. It is going to kind of cover the things I will not get to cover next week. It looks like the judge in the Petito case denied all of the motions. I might cover that. We'll see. We have a lot of things to cover for next week's podcast, and then I will be back the following week. So I will miss you. I will be around the socials. I am generally most active in our member spaces and on Instagram. So if you don't follow me on Instagram and you do the Instagram things, follow me there. And I will see the members tomorrow afternoon at 12:30 as I get ready to VidCon. I cannot stream at VidCon. If I am bringing my stuff, if something absolutely wild happens, we'll see what happens. But I do not intend to stream it all next week. I will miss you. I will be on the West Coast. I will be keeping you up to date on social and then doing members only behind the scenes stuff. So with all of that, I can't guarantee I can stream at VidCon because I have a lot of meetings planned. Some really exciting ones. So I'm excited to see internet friends that I've never met in person. I'm excited to meet creators that I've been friendly with on social that I've never met in person. I'm really excited about it. I'm also like so socially anxious because going to a new event where like I kind of know people, but I don't have like my buddy. Like BravoCon was so easy to run around because like Adam and I were buddied up. It was like, hi, we've got this together. It's a little bit different, but my team will be there and that's going to be really fun. So Team Baker will get to run around. So you'll see Octo running around with me, and Chris running around with me at VidCon. But there are some creator only spaces that I have to go socially awkward at people and be like, hi, I'm Emily. I know you from the internet. Nice to meet you. So that'll be an absolute delight. Oh, the creator that's speaking after my talk on Friday is Sophia Nygaard. I'm so excited. I'm like, are we going to be in the green room at the same time? Do I get to meet Sophia? I'm so excited about the potentiality. There are a few creators that'll be there that I'm like, very excited to see them. So with all of that, I will talk to all of you soon. So thank you, Law Nerds. Enjoy. Thank you for being here. I appreciate you. My neurodivergent 30-year-old will be looking for you at VidCon. Tell them to say hi. If they just say my name, I will know. Just tell them to say hi. I love that for sure. My hub says, hey, isn't that the show Emily always talks about? I can't look away from VPR. I gave in. Pepper Jelly, it's totally fair. It's totally fair. It's totally fair at all. Scottish Jason. Hello, Scottish Jason. This is a great question. Have you seen the clip of the hot mic at the end of the recent hearing where Kouri says to her lawyer, I'm not going to make it? I have not seen that. The judge makes a pretty impressive record and says a jury could find this based on this evidence. The evidence they presented at the bail hearing was a snippet of what they have. Is this type of public hearing with all that evidence normal? Yes. All the hearings are public. They're televised in cases that people are interested in. The hearing for Josh Duggar had that much evidence. It just wasn't streamed because it was federal court, but it was open to the public via Zoom. So I sat in for the 5.5 hour bail hearing on the Josh Duggar case, and it was a tremendous amount of evidence. So yes, it's not abnormal. It doesn't happen in every case. Some defendants are like, if defendants have a record and stuff, it's different, but it's not uncommon for defendants in serious cases where they have a record. So, or where they don't have a record. Where they have a record, it gets a little harder for them to get bail in the first place. So with all of that, thank you. I will see you soon. Have a great weekend. Take care of yourselves. Take care of each other. Law Nerds, go show QuickBits some love. That'll be up for you on Monday. And I will see you, well, members, tomorrow. I'll see you tomorrow. Bye.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at The Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, QuickBits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.